hearts will be aware of how this is going to shape it for your daughters, your wives, your friends, and your neighbors. And for the future generations to come, because the Constitution Amendment is not just for us in this chamber. It's for my future grandchildren, boys, girls, it's for all of them. This applies to us all. And I hope history is going to show that we stood for assuring safety for our boys, for our girls, for everybody. I hope you'll vote yes for the A15. Thank you.
The member from Isanti, Representative Johnson.
Madam Speaker, members, I hadn't planned on speaking on this amendment, but I had to. But first of all, I want to congratulate Representative Gilman on 30 years of marriage. Unfortunately, that doesn't happen as much anymore. It's too easy when times get tough to just walk away instead of try to work out the problem. So congratulations, Representative Gilman. Now, the A15 amendment, it does what our Constitution tells us to do. Our current Constitution, Article 1, Section 1, the government is instituted for the security, benefit, and protection of the people. Now, of the people isn't one person or one group or another group. It's all the people. And all the people deserve equal rights. Not giving special rights to certain groups or certain things, but all the people, every single one of us. And for me, I believe that's from the womb to grave. Now, we also have an obligation by our Constitution, and that is to protect everyone, every person in this state. And it's to do that, we have to do our best to keep every person from being a victim of a crime. That's what this amendment does. It gives some space, some privacy, a right to privacy for those who've already, a lot of times, have already been a victim of a crime, to make sure they're not abused or taken advantage of again. That's why this amendment is important. Members, please support the Scott Amendment. It's the right thing to do. It's the proper thing to do, and something that we must do by our Constitution at this time. Vote yes on the amendment.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker and members. Thank you for a really good conversation about the fact that women and girls need safe spaces. It should be something that we really have to debate about. I'm wondering if the author would yield to a question, Madam Speaker.
She will. Representative Scott.
Thank you, Madam Speaker. Representative Herr, is it the legislative intent of your bill that there be separate places, accommodations that have sex-based distinctions?
Representative Herr.
Madam Speaker, Representative Scott, it is the intent of this bill, because it is a constitutional amendment, that state actors operate in a way that is in line with what is outlined in this particular bill.
Representative Scott. Members, I would remind the body that we are on the A15 amendment. Representative Scott.
Yeah, thank you, Madam Speaker. I'm not sure what that answer really was. It seemed fairly circular. Would Representative Herr yield to another question?
She will. Representative Scott.
Thank you, Madam Speaker, excuse me, I'm so tired. Representative Herr, I have here from the Department of Administration, there's a grant program, a couple of grant programs out there, and the people that can apply are Asian Americans, African Americans, Hispanic Americans, Indigenous Americans, women-owned businesses. All these are like businesses that are owned by these people, various minority groups, and the disabled. And so I'm wondering, under your amendment, do you think that the ERA could possibly dilute opportunities for biological women in this respect?
Representative Herr.
Madam Speaker, Representative Scott, I would just like to draw the body's attention to lines 2.7 and 2.10, that this section is self-executing. It does not limit or narrow existing rights in the Constitution. Nothing in this section shall invalidate or prevent the adoption of any law regulating programs, practices, or benefits designed to prevent or remedy discrimination on the basis of characteristics listed in this section. And so the current programs in place that it addresses communities that have experienced discrimination in the past, it should not impact those programs.
Representative Scott.
Well, thank you for that fairly direct answer. I really appreciate that. One of the things that was stated earlier was that, and this was from the bill's author members, was that if the state laws allow for this amendment, the A15 already, and I'm going to question that that's already, that this language is really already in law. Because Anoka Hennepin schools were sued over a biological male who wanted to use the women's locker room. And so if the amendment is already allowed for in law, then how was this lawsuit, what was the basis for this lawsuit then? Representative Herr, if she would yield, Madam Speaker.
Representative Herr will yield. Representative Herr.
Representative Scott, that is all. I guess I'm confused by the question about passing a law that will impact something that is already governed by current laws right now. So I guess if you could clarify, if you're trying to ask me to apply this retroactively, how would it impact the situation? I guess I just want to try to understand the question that's being asked, because what is in place right now is in law, and that is what is being challenged. And when this is passed, because this only applies to state actors, whatever situations that are being litigated right now, those things will continue to be depending on their circumstances of the situation. So I guess I just want to make sure I understand what you're trying to ask me about if this gets passed, how it gets applied to things that are getting litigated right now already.
Representative Scott.
Thank you, Madam Speaker. Representative Herr, earlier you said that my amendment wasn't needed, that there are already laws protecting what this amendment is trying to protect. But my point is, if that's the case, then how could it be that the lawsuit brought by two Anoka Hennepin schools, it shouldn't have had any standing in court? I'll move on. I'll move on. And Representative Reier, is she on the floor? Yes. Representative Reier, I'm really sad to hear that you spent time in a women's shelter. That's, I don't know what that would be like, and I'm really sorry about that. But one of the things you did was you read from the Constitution, and you said that there is nothing in the Constitution saying that trans people don't have rights, which is correct. There's nothing in the Constitution saying they don't have rights. I thought that's why we were, why are we here then? What we're trying to establish here, folks, is that there shouldn't be a hierarchy of rights. Everyone, and this is what Republicans believe, they believe in equal rights for all. We don't believe in a tiered system of rights. All means all. Equal rights must include everyone. Folks, today, I'm guessing that some of you have been receiving emails and phone calls into your office about this upcoming ERA. And I've gotten quite a few myself. In fact, I got one today, and I wanted to read parts of it. Dear Representative Scott, my youngest daughter recently joined and I won't tell you which the swimming club it is, but she recently joined a swimming club. And the mother goes on to say, it's terrifying to realize our daughter's dream of joining a swim team is hinging on the fact that a biological male can invade the locker room of not just our child, but that of many, many other girls. She said, the rules in swimming are endless, to the point where parents cannot take video or photos during practices and meets, yet a biological male could enter a female locker room? Say nothing about the inaccuracies of a male competing against a female. Outrageous. She gave me a link to all these different rules that exist to be on this swim team, on this swim club. It says the rules are endless in sports, but where are the rules protecting our daughters? Folks, Minnesotans are watching this. They're watching this debate probably more closely than I've seen a debate of this nature, a cultural sort of thing, be debated. And they're weighing in. And it doesn't make sense to them that we would be doing something like this in the legislature. We've gone over this a couple of times, that Minnesotans need to know what they're voting on. That's what we're trying to establish with this debate. 64% of Minnesotans believe the questions of equal rights, and we haven't gotten to the abortion issues yet, and unlimited abortion up to birth should be separate questions. We cannot have, as Representative Ann New Brindley said, we cannot have this tiered system of trans rights up here, trans women, and then the rest of women. That is what this amendment is establishing. I want to end by reading a paragraph from an article that I came across by Helen. Let me find it. Too long of a period of time off here. Here it is. Helen Joyce, and she wrote an article entitled, "The Trans Movement Wants to Take Away Women's Rights." And this was from August of 2021. But I thought what she had to say was really interesting here in the last paragraph. It says, it's all become about gender self-identification, which is this idea that all of us have an innate thing inside ourselves, a kind of sexed soul. This, and not our biology, is the thing that makes us a man or a woman, or possibly something else, non-binary or gender fluid. If that's what you believe, you have to rearrange everybody's rights. Because some of our rights are sex-based, like the right to single-sex accommodation or sports. If you rearrange the world so that everything is done according to what people say they are, you take away rights from the people who want it done according to their sex bodies. I thought that was so well said. Members, please, I ask you to have some common sense here. Protect girls and women in safe spaces. Please vote green.
The clerk will take the roll on the amendment. Will the clerk please call the name of the member voting remotely?
Carol. no.
Carroll, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
New Brindley moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A28.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker. So the A28 amendment is really about what authority the legislature will have if this amendment passes. And it simply says that nothing in this section prohibits the legislature from regulating health care, including but not limited to gender-affirming care and reproductive health care. And I want to talk about this for just a minute because I actually think that this is a really important piece. Last year on the House floor, Democrats passed the PRO Act, which enshrined into law the most radical abortion policy in the country, allowing for abortion for any reason, at any point in pregnancy, via any method. That's what was enshrined into law 1 year ago. But that misses the boat, and we want to ensure that the legislature still has some authority here. And I want to give some examples. Number one, and kind of an easy one, is I was thinking about an amendment, and I think a bill that Representative Scott carried previously. And it was a requirement that a chemical abortion needed to be administered in a facility where a woman receiving an abortion had contact with a healthcare provider, had direct contact with the healthcare provider. And I immediately signed on and said, I'm on board. This is really important. And let me tell you why. 16 years ago, this summer, I had an experience. This is why I know how important this is. 16 years ago, I had an experience. I was pregnant and miscarried. I miscarried that baby. It was early in pregnancy, but I had a miscarriage. And things seemed to be going fine. It seemed like my body was just readjusting after having a miscarriage. And however, let me be very clear. After I had this miscarriage, had the miscarriage at home, this was my 6th pregnancy. Frankly, I didn't think much of it. This was old hat to me, frankly. And so I didn't think much of it. Everything seemed okay. I didn't bother to go to the doctor to ensure that everything was okay. And 2 weeks later, I happened to be just down the street in Regions Hospital, visiting a friend, and with another friend. And as we were leaving, I told this other friend, you know, I do not feel good. Can we just go back down? I just want to go to the bathroom real quick. And as soon as I said that, I started blacking out. And the world started spinning, and I blacked out in the hospital. I could still hear I was still standing, but I blacked out. And we got to the main level. I saw a chair across maybe 10 feet away. I went to sit in it. Kathy got a wheelchair. She found one quickly. I sat down, and Kathy said I just immediately slumped over in the chair. And fortunately, we were in Regions, like, right down the hall. We were literally feet from the emergency room. So I was able to receive medical attention immediately on the spot. And we got to the ER, and they put a blood pressure cuff on me. they told me, I forget what the word is, recall from my college days, but hyper or whatever, I was sweating. and I said, what does that mean? And she said, you're sweating a lot. And as soon as she said that, I could feel sweat coming from every pore, like on my legs, everything. My body was trying to dump fluid to get my blood pressure back up. And Kathy, the friend that was with me, said that they ripped the blood pressure cuff off, said code something, and she said the entire emergency room stopped and everybody went to the room that they were taking me. As it turns out, 2 weeks later, I had an ectopic pregnancy that ruptured. And I never bothered to go to the doctor after that miscarriage because I thought, well, it's fine. This is normal. It happens. I didn't realize how important it was that I go to the doctor, that I have an ultrasound, that they make sure that all the tissue passed properly, that I was going to be okay. I didn't realize how important that was. But by the end of the day, my symptoms were very odd. It's actually unusual, I had no idea. It's very unusual for an ectopic pregnancy to grow large enough to rupture because it's super painful. And so most women go to the doctor before that happens. For whatever reason, I had a high tolerance of pain. I don't know. I didn't know. I had no idea. But by the end of that day, my symptoms were presenting odd, so they couldn't do a laparoscopic surgery. They had to open me up, do a double tubal ligation. I had hematomas on my ovaries, and I had lost 1.5 liters of blood, which is a lot of blood. And all that happened because I did not know, I know it sounds so silly, again, 6th pregnancy, I should have known better, but I did not know how important it was to go to the doctor, to have an ultrasound, and to make sure that everything happened as it should have. Because had I done that, had I gone to the doctor after that miscarriage, after that spontaneous abortion, had I gone to the doctor, they would have known immediately that I had an ectopic pregnancy. And that fallopian tube never would have ruptured. I would be intact today, likely. I tell this story because there are reasonable things that to legislate to ensure the safety of women. A chemical abortion is not without risk, the biggest risk of which is not passing everything properly. And needing follow-up surgery, etc., after the point. But there is real risk for women in this. So when Representative Scott had that, I immediately understood the wisdom, understood exactly why this matters, and signed on. So that's just one example of why we need to make sure that nothing in this section prohibits the legislature from regulating. I look at things like, at the federal level, there is a ban on partial birth abortion. Because aside from here in Minnesota, as a society, nearly everyone has agreed that there is absolutely no reason to allow this absolutely barbaric practice. It's absolutely barbaric. And in fact, there's a federal ban on partial birth abortion because of that. And that ban actually has stood up to judicial scrutiny. In 2007, it was upheld. And here in Minnesota, we should have the option of ensuring that that doesn't happen here. On the flip side, I was reading through the governor's executive order on gender-affirming care. And in that executive order, the governor actually cited a study on gender-affirming care, medical gender-affirming care, showing that over 13% of transgender people who receive gender-affirming care chose to detransition. This was a study cited in the governor's executive order. You can imagine how surprised I was to see that there. And that number amounted to 2,229 people out of 17,151 who chose to detransition. That was in the governor's executive order. That's actually where I found that study cited. Understanding the lifelong effects of medical gender transition that cannot be undone, it is reasonable to think that a future legislature may have even more information than we have now, and that it would be prudent to have legislative insight into how this is applied. That perhaps medical gender transition for minors and the lifelong irreversible changes are not prudent. And as a legislature and as future legislatures, not only should they have the right to ensure the safety of all Minnesotans, they have a duty. They will have a duty to ensure the safety of all Minnesotans. But let's be very clear, right now, in this underlying unequal rights amendment, as drafted, there are no limitations, there are no guardrails for abortion or medical gender transition. Not for kids, not for women. No measures to ensure women are safe if they do choose to have an abortion. No measures to protect children from lifelong decisions that they may not really understand yet. And so, members, we have a duty as a legislature to ensure that future legislatures have the ability to perform that duty, to use the best information they have at the time and make decisions to ensure that women and children are safe. Madam Speaker, I would ask for a roll call vote on this.
Representative New Brindley requests a roll call. Seeing 15 hands, there will be a roll call. Representative New Brindley.
Thank you, Madam Speaker. And members, I would request a yes vote on this.
Discussion on the New Brindley amendment. Representative her.
Madam Speaker, Representative Brindley, and Representative Brindley, thank you for sharing your story. I can't imagine how painful that might be, and I think that you and I think I would consider you a friend. You and I talk a lot off the floor too, and I think that this is one thing that you and I actually share very much in common. I've actually shared this story in the past before, that my first pregnancy was an ectopic pregnancy, except for because it was my first, I was spotting, and I went to the doctor, and they told me it was an ectopic pregnancy, and I did have an abortion. I had an abortion to save my life. And so I think that it is really important that government does, continue to be able to regulate health. The legislature continues to be able to regulate health care. It currently has that right now to do that. And the passage of the ERA, it doesn't change that. So government will continue to regulate health care. However, if that regulation violates someone's rights, it requires the state to use the least restrictive means of achieving a compelling governmental interest. So again, this is constitutional standard law. This is constitutional law standard, and so I recommend a no vote to this. But I want to again say thank you for sharing your story, and I think that we all have to be able to make the choices best for our bodies and what we are experiencing in our life, and that's a decision between us and our doctors, and that government and our state continues to be able to, the legislature continues to be able to regulate that, and nothing changes again with this passage of the ERA. So I recommend a no vote.
The member from Hennepin, Representative Robbins.
Thank you, Madam Speaker, and thank you, Representative Newt Brindley, for bringing this amendment. So I want to go back first to the point that we have a very robust State Human Rights Act. And what we're talking about now is a constitutional amendment. And the State Human Rights Act is very robust, and it includes all of the categories in the constitutional amendment, and it also includes age and religion, which the constitutional amendment does not. And the reason the Newt Brindley Amendment is so important is because, as we talked about before, it raises the court's treatment of gender and sex from intermediate scrutiny, which is the mid-level, to strict scrutiny. It will be much harder to prove a compelling interest than current federal and state law allows, because they acknowledge there are actually state interest reasons for treating sex differently in some situations. So this science of hormone therapy and gender-affirming care is really evolving. And putting something like this in the Constitution without the Newt Brindley Amendment would make it really difficult at the highest level of scrutiny for the state to pass laws that are following science as it develops. So back when the Obergefell decision was made by the Supreme Court in 2015, not that long ago, 9 years ago, the court held that psychiatrists and others recognize that sexual orientation is immutable. That was the standard. Since then, many people have come to believe, as was articulated on the floor tonight, that there's a continuum and that your gender identity can be chosen, it can change, and so it's not settled at all, members. And so there's a lot of effort going on around the world to think about what's the best way to provide gender-affirming care. And the experience of our friends in Europe who are ahead of us on this is that they are pulling back. So they are passing laws that if we adopt this amendment without the Newt Brindley Amendment, that we would have trouble passing. And what they're doing in Europe is they are pulling back on gender-affirming care for minors because they are very concerned about the health, physical health, psychological health implications of making life-altering decisions like this. So, and interestingly, it's not that political there. as I was reading some articles, they said these laws aren't being pushed by legislators. It's not politicized like it's in the US. The institutions are changing it based on the level of medical risk they see. So, so in Sweden, Norway, the UK, they have all significantly reduced the gender-affirming care for minors. Age is not in this. So a law that we pass to protect minors from life-altering harm as the science develops might not be workable under this constitutional amendment. In Sweden and the UK, they've changed hormone treatments for minors only for research purposes. You cannot get them from your doctor anymore. In Norway, they've said that gender-affirming care such as puberty blockers are now defined as experimental. And in France, in February of 2022, their National Health Alliance recommended greatest reserve when considering puberty blockers or hormone treatments due to possible side effects such as impact on growth, bone weakening, risk of infertility, and other complications. So while we in the US are forging ahead to allow minors to make these life-altering decisions, people who have been on this path longer than we have are putting the brakes on. And if we do not adopt the New Brindley Amendment, we will be severely limiting ourselves and future legislators from passing laws in the best interests of children in Minnesota who could be forever harmed by treatments that are experimental. Members, the New Brindley Amendment is just common sense. Please vote green.
The member from Goodhue, Representative Altendorf.
Thank you, Madam Speaker, and thank you, members. I just rise, I need to clarify something because unfortunately, one of the things that I believe the Democrats, the majority party, talk about is ectopic pregnancies and that they are abortions. And that is just not correct. And in fact, there is no state that does not allow a woman to treat, I'm sorry, I gotta pull this up here a second, an ectopic pregnancy. Just to quote here, so from Texas state statute, an act is not an abortion if the act is done with the intent to save the life or preserve the health of an unborn child, to remove a dead or an unborn child whose death was caused by a spontaneous abortion or a miscarriage, or to remove an ectopic pregnancy. And I just think it's really, really unfortunate that we are using these scare tactics, that we are telling the public that they have to have an abortion provided to them, or that they could not have an ectopic pregnancy, or if they had a miscarriage, that would be considered an abortion. It is not. It is not. It is not. And it's really quite disgusting that we are characterizing it that way.
Representative New Brindley, closing argument.
Thank you, Madam Speaker. I hope that folks will see the wisdom of this amendment. As Representative Robbins said, it's not just as easy as Representative Herr would lead us to believe that we have the right. Everything will continue as is. Government will continue to have the ability to regulate health care. This unequal right amendment changes that significantly. And we do not want to hamstring future legislatures from implementing not only current information, but perhaps new information that we don't even have right now. We want to ensure that legislatures always have the ability to make the very best decisions for the time that they are in. And I would request a green vote.
The clerk will take the roll on the amendment. Will the clerk please call the name of the member voting remotely?
Carroll.
Carroll, no.
Carroll, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Perryman moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A25.
The member from Stearns, Representative Perryman.
Thank you, Madam Chair. My amendment, A25, simply clarifies the new section of the Constitution does not require the expenditure of public funds to address previous discrimination. And let me explain that. Within SF 37, there is a disclaimer contrary to the stated intent of the proposed amendment to guarantee equality under the law. This provision 2.8 to 2.10 allows laws, regulations, programs, or benefits designed to prevent or remedy discrimination on the basis of the characteristics listed in this section. This section allows spending programs intended to benefit women or communities of color would not be unconstitutional by the very same section. However, the concern is this new section of the Constitution will be used to force the state to enact and pay for programs to remedy previous discrimination. So this is just a few notes to explain what I'm saying here. This amendment would ensure that judges do not feel compelled to require public funds as a remedy to violations of this provision. It limits judges from making broad public policy decisions that have a fiscal impact without legislative approval. It is a protection of the separation of powers. And it is not a ban on the award of public funds, and it is also not a requirement. For example, one-time damages award could be provided, but not necessarily a mandate of public funds via some new remedial policy. Members, I really will ask that this be considered. It's a simple amendment to, the current SF bill, and very simple and just very good clarification. Why wouldn't we want to clarify it? And members, I ask for a green vote, and Madam Chair, I ask for a roll call.
Representative Perryman requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the A25 Perryman amendment. The member from Ramsey, Representative Herr.
Madam Speaker, Representative Perryman, and Representative Perryman, thank you for coming to talk to me ahead of time around this particular amendment. I just do want to just repeat what I said to you, is that the substance of remedies is actually not discussed anywhere in state constitution. There is one Section 8 in our Bill of Rights that talks about redress of injuries or wrongs, but it doesn't specifically state like what the remedy would be. And for this to be placed, it would be the only thing in our Constitution that would actually state the remedies, and so I'm going to ask for a no vote from the body.
Discussion. The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and I have a follow-up question for the author, if she will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker, and Representative Herr, in the Rules Committee hearing, I believe you were asked if there's a private right of action under this constitutional amendment if it were passed, and I believe your answer was, or the answer of counsel that you brought up to the table was that there was a private right of action. Is that correct, that there is a private right of action for people to sue the state of Minnesota under this constitutional amendment if it's passed?
Representative Herr.
Madam Speaker, Representative Niska, yes, Minnesotans have a private right of action.
Representative Niska.
Thank you, Madam Speaker, and I have a follow-up question for the author, if she will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker, and Representative Herr, what sorts of remedies then are available to individuals who do sue the state of Minnesota under the constitutional amendment that you are offering? Can they get an injunction against the state of Minnesota prohibiting or preventing the state from violating this constitutional amendment?
Representative Herr.
Madam Speaker, Representative Niska, so it's not that I'm not trying to answer your question, is that I would need to know. I mean, I actually really did look into this a lot. I talked to lawyers and civil rights lawyers and constitutional lawyers, and I asked them about the situation, and they said to me, well, you know, we really have to know who the state actor is, what the circumstances are, which one is the state actor? Is it the state itself? Is it a county? Because then, you know, it goes to a county attorney. So I really did try to figure out, but there is no simple answer for me just to tell you that this is what would happen with that. And so it's not that I'm not trying to answer your hypothetical, but that there's actually many steps in between depending on who the state actor is and where it's litigated. And so I don't know if you, like I said, I don't want to be sitting here trying to answer 100 hypotheticals about what particular situation at which level of the state actor. And so I hope that, you know, it's not that I don't want to answer, but that's the best I could give you. If you have a very specific thing, I'm sure that my colleague, Representative Dave Pinto, would probably be better at entertaining specific scenarios that you might have for him to answer.
Representative Niska.
Thank you, Madam Speaker. And actually, that was quite a good answer, Representative Herr, which is pretty much everything's on the table, depending on the issue. And so the problem with this kind of a very sweeping amendment, and in particular, we had a long discussion about the concern about the words "in effect," discriminate in effect on the basis of any of one of these categories. Anything is on the table. And that is really concerning for our form of government. When you talk about a lawsuit that could be brought against the city, or like you suggested, a county or the state, on account of a claim that something that the state actor is doing would in effect discriminate on the basis of one of these categories. So there are lots of decisions that are made by the state, including decisions that are made regarding funding, that have potential arguments for disparate impact against the state. And so I think your answer is actually 100% correct, which is we don't know. Probably there would be remedies, injunctions against state actors that would involve a judge telling the state, or telling Hennepin County, or telling the city of Minneapolis, or telling any host of government entities that, in fact, the budget decisions made by their democratically elected representatives are not going to stand. So the budget decisions that we make on behalf of the people who elect us to this body are not going to stand under your constitutional amendment. I think that was your answer, and I think that is 100% correct, and that's exactly why we need this Perryman Amendment. There is a reason why in the Constitution it says, our current Constitution, which I think this is going to override or supersede, it says that spending decisions have to be made by the legislature. The reason our Constitution is set up that way is because we are a government of the people, by the people, for the people, not government of lawyers, by judges, for activist groups. That's what your amendment turns us into. It turns the state of Minnesota from a democracy into a state run by judges, into a state run by lawyers, into a state run by activist groups that bring lawsuits and get judges to order the state to change laws or to spend money in different ways than what the democratic process allows. So this is a fundamental change in the form of government in Minnesota. the underlying amendment. And that's why the Perryman Amendment is so important. So thank you for your clarity on that, Representative Herr. I hope the people of Minnesota are paying attention. You're being asked to give up democracy under the guise of equal rights, under the guise of non-discrimination. You're being asked to cede your power to hold your elected officials accountable for the spending decisions they make so that Gender Justice and other activist groups can go to the courts and get the courts to order the state of Minnesota or your county or your city to tax and spend in different ways than what you would agree to. That's what this amendment does, unless we adopt the Perryman Amendment. So that's the question before the body. Are you for democracy or not? Are you for democracy or not? If you're for democracy, you'll vote for this amendment.
Further discussion. Representative Perryman.
Thank you, Madam Chair. May I ask the author a question?
You may. She will yield. Representative Perryman.
Thank you, Madam Chair. Rep. Herr, I have a quick question. After Representative Harry Niska's talk, there is if we do have this instance happens and the mandate is a result of a claim, how will the state find funds to pay for the mandates caused by the ERA? Will it mean that taxes are raised for programs or something to pay for these kind of lawsuits if we do have some actions towards something that happens with the ERA?
Representative Herr.
Madam Speaker, Representative Perryman, so I just want to address what Representative Niska said first, that's already how law works right now. That's already how lawsuits happen right now. Nothing changes with how processes work when people challenge what is in our current Constitution versus what is in a law right now. Nothing changes. So passing the ERA means everything stays the same. Representative Perryman, I'm not quite sure what your question is asking me. I don't know what you're meaning because, again, like we stated to my response to Representative Niska, it depends on who the state actor is, and so the state doesn't pay for everybody's lawsuits or every settlement. That's not the way it works right now.
Representative Perryman.
Thank you, Madam Chair. Thank you, Rep. Herr. Well, I would hope that, again, I think I always end my amendments with saying I'm putting my sales hat on again, and that I hope that you'll consider this and light up the board green because of democracy and what we need to get done, and just clarification. One little paragraph in it, and that we should be always adding clarity to anything we write so it's very clear. So thank you, and let's get a green board. Thank you.
The member from Olmsted, Representative Quam. Sorry, Representative Perryman, a couple of folks popped up during your closing argument. Representative Quam.
Thank you, Madam Speaker, and this is not the first amendment I've heard. Nothing changes. It's already law. Why are we doing this constitutional amendment if all the components are already there and nothing changes, according to the author? I think our amendments are bringing up things that we need to clarify before doing a constitutional amendment, which is not trivial. And almost every argument we come up with, that's the way it already is, nothing changes. And people watching, that's not true.
The member from Hennepin, Representative Robbins.
Thank you, Madam Speaker. I'm sorry to speak again after Representative Perryman, but I just have heard the authors say over and over that it depends on who the state actor is. So if Representative Herr would yield to a question.
She will yield. Representative Robbins.
Thank you, Madam Speaker. So Representative Herr, I've had it written down multiple times from different sections of this debate that you keep saying it depends on who the state actor is. It changes that we have to define who the state actor is. So could you please tell us who constitutes a state actor under your amendment?
Representative Herr.
Madam Speaker, Representative Robbins, I'd like to direct you to lines 2.5 to 2.6. It talks about the purpose of this section. The state means the state or any agency or political subdivision of the state, and so that's where it's defined.
Representative Robbins, just a reminder, we're on the 825 amendment. Representative Robbins.
Thank you, Madam Speaker. Yes, but this does go to the 825 because who the state actor is depends on the use of public funds. And this is about, the amendment is about the expenditure of public funds. And we had a lengthy discussion, I don't know when, earlier in this debate about whether a state actor is a nonprofit, a church, a hospital, anyone who receives public funds. And the definition that Chair Herr read just now from the actual amendment, it's not clear. State means state or any agency or political subdivision of the state. So if you're receiving state funds, it could be construed that you're a state actor. And the testimony in the Rules Committee, Chair Herr did say if you got public funds, you would be captured under this state actor definition. And so this is critical to the Perryman Amendment members. If we do not have clear understanding of whether any group that gets public funds is considered a state actor, it will open the door to all these lawsuits of the church in your town that has a daycare center, the food banks, the hospitals, the groups that do such good work in our communities are all at risk members. So we have to understand this definition. So Chair Herr, if Chair Herr would yield to one more question.
She will yield. Representative Robbins.
Thank you, Madam Chair. Thank you, Chair Herr. So if a daycare facility uses state dollars to pay for childcare, or if a medical facility takes Medicaid patients, would they be construed to be a state actor?
Representative Herr.
Madam Speaker, Representative Robbins, I'm going to remind us of the conversation we had earlier about this, is that receiving public dollars does not automatically make you a state actor.
Representative Robbins.
Thank you, Madam Speaker. And that is exactly the answer we had last time. It does not automatically make you one, but we tried earlier in earlier amendments to explicitly have an amendment saying if you receive state dollars, you are not a public actor. And clearly, she's saying it doesn't automatically make you one, but you certainly could be one. So members, we are opening up every group in this state to lawsuits under this constitutional amendment, which, if I have to remind everyone again, is at the highest level of scrutiny. The Perryman Amendment is essential for anyone who gets state dollars in our communities to be protected from the implications of this and shutting down very important work that's going on in all of our communities right now. Please vote green on the Perryman Amendment.
The clerk will take the roll on the amendment. Will the chief clerk please call the name of the member who's voting remotely?
Carroll.
Carroll, no.
Carroll, no.
The clerk will close the roll. There being 63 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. Representative Long.
Madam Speaker, I move that Senate file number 37 be laid on the table.
Representative Long moves that Senate File 37 be laid on the table. All those in favor, please say aye.
Aye.
Those opposed, please say no. The motion prevails. The bill is laid on the table. Representative Long.
Madam Speaker, I move that the vote whereby the House adopted the Conference Committee report on House File 5242 be now reconsidered.
Representative Long, would you like to make a motion first to pull it off the table? Representative Long.
Yes, I would like to make that motion.
Representative Long moves to pull Conference Committee report House File 5242 from the table. All those in favor of the motion, please say aye.
Aye.
Those opposed, please say no. The motion prevails. Do you need The clerk will report the bill.
House file number 5242 is amended by conference.
Representative Long.
Madam Speaker, now I move that the vote whereby the House adopted the Conference Committee report on House File 5242 be now reconsidered.
All those in discussion to the motion on reconsideration. The member from Morrison, Representative Schultz.
Thank you, Madam Speaker. Yes, this is a pretty big bill, very important to the citizens of Minnesota, and I think it is worthy of our reconsidering whether or not we would take action on this bill. I actually am of the belief that taking action on this bill would not be in the best interest of the taxpayers of the state of Minnesota, whether it's from the business regulations, the labor regulations, the burdens that this would be for Minnesotans. I would say that we should not take this up, and the citizens, especially considering we only have approximately 25-ish hours left in this legislature. There are a few other bills I would say would come as a higher priority, both to me and to the citizens of Minnesota when you consider some increased fees. And like I mentioned, a whole host of different regulations that are going to make Minnesota more unaffordable for the people, that we should not move to take this bill from the table. And frankly, I think that we don't need a vote on this bill tonight. Thank you, Madam Speaker.
Representative Long.
I agree. Let's reconsider it.
Representative Petersburg.
Thank you, Madam Speaker, and to if Chair Hornstein would rise for a question.
He will. Representative Petersburg.
Thank you. Now I was on the conference committee, and we had finished all our work. The Senate agreed and closed it all up. Do you have a reason for opening this back up? Do you have any information as to why we should do that?
Representative Long. Representative Hornstein. Representative Hornstein will yield to Representative Petersburg, who has the floor. Representative Hornstein.
My understanding is that there's an additional issue that needs to be considered.
Representative Petersburg.
Thank you, Madam Speaker. Well, maybe it should be Representative Long that I should ask as to why we are opening up this conference committee that has been closed, and Senate is already working on other things. Why we would be opening it up?
Representative Long.
Thank you, Madam Speaker. Yes, we are reopening the conference report so that we can include the agreement that we made tonight with Uber and Lyft. This is appropriate for the Transportation Conference Committee.
Representative Petersburg.
Thank you. I'm surprised because I thought this was something that had been agreed to and would be a standalone bill for Uber and Lyft rather than putting it into a conference committee that we already closed. So I'm not real crazy about opening it up. If it's something that is an agreement by the DFL leadership, then I think they ought to just pass it and put it in a bill by themselves. So I would recommend not reopening it and not reconsidering.
Representative Nash.
Thank you, Madam Speaker. I guess I'll ask the Majority Leader to yield to a question since this is his motion. Could you tell us, Majority Leader Long, when we'll see the conference committee posted so that the public can come and observe the deliberations and perhaps the proposed language, since I'm sure all of our members and yours would probably like to be able to see that as well as the public?
Representative Long.
Thank you, Representative Nash. I'm sure that the chairs of the conference committee will be posting the meeting notice ahead of time, and that we will also be posting the language ahead of time when it is available with plenty of time for review.
Representative Nash.
Thank you, Madam Speaker. And Representative Long, if you'll continue to yield.
He will yield for another question. Representative Nash.
Thank you. And I'd just like to be able to confirm that the language is in hand and that our members will be able to see it, because I believe that we'll be continuing this deliberation. We will be seeing this on the floor, if you're going to be adding it into the bill, and when do we have an expectation of when this will actually be posted and gavelled in for the conference committee?
Representative Long.
I do not have that information at the moment, Representative Nash, but I can assure you that the conference committee will be held with full public review, and that we will have the ability to review the language ahead of time.
Representative Nash.
Thank you, Madam Speaker. And are there going to be sufficient notifications and times for amendments and public testimony, and just making sure that, just like every other conference committee that I've been on and that we've all been on, that we have that opportunity for those people to take full advantage of what they, as the public, should expect?
Representative Long.
There absolutely will be opportunity for public review.
Representative Nash.
Well, that news makes my heart soar like a hawk, Madam Speaker. I just want to make sure that we get that posted and that we have that, so that we're not trying to rush through things here, and it's getting close to the dark of night. I think we're going to be arriving there soon, and I just want to make sure that we do know where that's going to be. Is it going to be here in the Capitol? Is it going to be in 120? I mean, just give us a couple of guidelines, if you could.
Are you asking him to yield again?
I am asking him to yield, yes, Madam Speaker.
Representative Long.
Madam Speaker, I don't chair the conference committee, nor do I control room assignments, but I am sure that there will be posting with ample time for folks to find the room.
Representative Nash.
Thank you, Madam Speaker. Well, I'll ask Chair Hornstein to yield, if he would.
He will yield. Representative Nash.
Thank you, Madam Speaker. Chair Hornstein, you and I have a great relationship, and I respect you tremendously. Can you guarantee that we will make sufficient announcements and make sure that the public has ample time to perhaps get here, since it's a tad on the late side, and want to make sure that those folks who are deeply interested in this, because there are many, many people who are very concerned by this, want to make sure that they have ample time to do that. So could you tell us when approximately you're looking at composing this conference committee?
Representative Hornstein.
Thank you, Madam Speaker. Representative Nash, I will be in contact with those who are finalizing the language, and it has been our tradition in this conference committee that we give ample notice and allow for public scrutiny.
Thank you, Madam Speaker.
Representative Nash. The member from Stearns, Representative Demuth.
Thank you, Madam Speaker. And would the Majority Leader yield for a question?
He will. Representative Demuth.
Thank you. Mr. Majority Leader, I just want to have an assurance, as there's going to be provisions that are actually put into the conference committee and then making its way back. Two questions. The first is, will we have ample time to fully look at that and debate the bill as it comes back with a new provision?
Representative Long.
Yes.
Okay.
Representative Demuth.
Thank you, Madam Speaker. And if he would yield for another question.
Representative Long will yield. Representative Demuth.
Thank you, Madam Speaker. Majority Leader Long, I just want to make sure that what is being put into this conference committee report will be germane as it relates to Rule 6.40. And I'm just going to read a portion of this for the body. This is where my question is coming up. It says, a conference committee report must include only subject matter contained in the House or Senate versions of the bill, for which that conference committee was appointed, or like subject matter contained in a bill passed by the House or Senate. The member presenting the conference committee report to the House must disclose all substantive changes to the House version of the bill. So my question is, Mr. Majority Leader, will this be germane according to 6.40?
Representative Long.
Yes.
Representative Demuth.
Okay, thank you, Mr. Majority Leader, and I understand this is being put in this. Is there a possible consideration of having this as a standalone so we don't end up running into a problem that could question the germaneness?
Representative Long.
Thank you, Madam Speaker. Thank you, Leader Demuth. We are very late in session and running very short on time, so we are trying to make sure we can get all our work done.
Representative Damath.
Thank you, Madam Speaker. And then for the body, I understand we are running short of time, but I would hate for this to come through and it would be not germane and there would be a problem. As we complete the questions or our debate a little bit on this motion, Madam Speaker, I would request a roll call.
Representative Damath requests a roll call. Seeing 15 hands, there will be a roll call. Further discussion. The member from Stearns, Representative O'Driscoll.
Thank you, Madam Speaker. And given the discussion on the topic this evening, I will remind the body that there are other mechanisms within our control and our rules to be able to expedite this. We have on a number of occasions major pieces of legislation, some of them having to do with agriculture, some of them having to do with other appropriations, with weather-related damage and the like, to bring that as an urgency to the floor, amend the language, send it over to the other body, and get a concurrence on that so that we do not end up taking what I'm hearing is precious time that the Democrats feel they still need in order to be able to complete their agenda for the 2024 session. So there is a very quick and fast way to be able to do this and to keep a promise on having this as a standalone bill. So I strongly encourage a support of denying or, on the motion to reconsider, to vote no on that and use the other tools that we have here in this body to be able to expedite those very important, apparently, developments from earlier this evening. Thank you, Madam Speaker and members.
Discussion. The member from Douglas, Representative Franson.
Thank you, Madam Speaker. Members, I think we have a lot of work to do left. I know that the Human Service Policy Bill has to be done yet, State Gov, and I believe taxes. And I know that the Senate is extremely far behind on our bills. Oh, yes, okay, so we still have here in the House, members, we have EMS, we have scope of practice, which is not closed, but taxes, we have queer panic, we have ERA that we're still debating, we have HHR, the historical horse racing, we have a corrections bill, plus we still have a bonding bill to get done. And members, I am going to correct the record. Representative Schultz, we have about 12 and a half hours, actually, not 12 and a half. It is 11 hours and 29 minutes. 11, did I say 11? Oh my gosh, I mean 23 hours and 29 minutes to go. Now, the Senate has taken an extremely long break yesterday and the majority of the day today. For whatever reason, I will not elaborate on what my thought process is on that quite yet, but that is not our problem. It is not the Republicans' problem that you, the majority, who has the entire government, that is not our problem that you don't know how to manage your schedule. This bill, this Uber Lyft bill, needs to go through the proper channels. We have zero public testimony, we will have zero thorough public testimony. It is doubtful whether or not Uber Lyft will be able to have customer or testimony from people who use Uber Lyft about how much this is going to raise costs for individuals who use that as transportation. And members, it is our job to make sure that this gets done correctly. Again, this is not our issue. This is a Minneapolis issue. They caused the problem. We have been wanting to work with you for months, actually, on this issue. We have said, hey, come work with the Republicans. You chose not to, and now we have 29 hours and 27 minutes left. 23 hours and 27 minutes left. I don't want to be here any longer. So 23 hours, 27 minutes left.
The member,
and we have a lot of work to go. We have a lot of work to go. So, members, I am going to stand with Representative O'Driscoll. I think we need to have a public, thorough vetting of that. Thank you, Representative O'Driscoll. I will not be supporting the motion to re-refer. Thank you.
The member from Brown, Representative Torkelson.
Well, thank you, Madam Speaker. If the Majority Leader would yield for a question.
He will yield. Representative Torkelson.
Representative Long, it seems like we have a simple approach to this. We have House File 4746, which is an Uber-Lyft regulation bill. Why wouldn't we do the simple thing and use that bill to get this moving quickly and cleanly without any challenging the rules to get this very odd process done that you have proposed?
Representative Torkelson, I am guessing you asked him to yield, and he's looking like he's going to
I
yield.
thought I did ask him to yield.
Okay, I was just a little step behind up here. He will yield. Representative Long.
Thank you, Madam Speaker. Thank you for the question, Representative Torkelson. We've determined this is the quickest way to work this out with the Senate and to get this bill done, and we want to use each of our 38 hours and 212 minutes that we have remaining to get this done.
Representative Torkelson.
Well, thank you, Madam Speaker. Thank you, Representative Long. I refuse to do math in public. It's dangerous. But I really fail to understand the logic here, Madam Speaker, Representative Long. This, you're challenging the rules. You're stretching the rules to force this into a bill that's already been approved. And you're going to open that bill back up in a way that is not appropriate because it's not part of that original bill. You're challenging the rules, you're forcing it in, and you've got a bill right here where you could run this alone and do it cleanly and quickly. There's something mysterious going on here that, I don't understand math in public. I also don't understand exactly what you're trying to do here. Representative Long, if he would yield for that question, Madam Speaker.
He will yield. Representative Long.
I think I was pretty clear what we're trying to do. We're trying to make sure that we have a statewide rate passed for Uber and Lyft drivers to make sure that they get fair compensation.
Representative Torkelson.
Well, Madam Speaker, you didn't answer my question. I don't understand why you wouldn't run this as a separate bill when you have that opportunity. That seems like the cleaner, quicker way to do it. We're going to have probably a long rules fight on this if you proceed in the way you are proceeding. If he would yield for that question, Madam Speaker.
Representative Long.
Thank you, Representative Torkelson. As I said before, we are taking this path because we've determined with the Senate that this is the most expeditious way to get this done.
Somebody bring them a calculator. Representative Long.
Thank you, Madam Speaker. So we had a good colloquy, and I think we are going to amend our plan, and we are going to continue to open up the conference committee, but we are, before we bring the bill back, we will make sure that we bring as a standalone the language, and so that we can establish a House position and pass it off the House floor.
Representative Torkelson.
Thank you, Madam Speaker. Thank you, Representative Long.
Further discussion on the motion for reconsideration. Representative O'Driscoll.
Thank you, Madam Speaker and members. Just for the record, we spent about 12 to 14 minutes discussing what would have taken us about 7 minutes to do procedurally. So we've lost 7 of those 38 hours and 242 minutes that the Majority Leader was speaking about earlier.
The clerk will take the roll on the motion for reconsideration. Will the clerk please call the name of the member voting remotely?
Carroll.
Go ahead.
Carroll, yes.
Carroll, aye.
The clerk will close the roll. There being 72 ayes and 52 nays, the motion prevails. The bill is before us. Representative Long.
Madam Speaker, I move that House File 5242 be returned to the Conference Committee.
Representative Long moves that House File 5242 be returned to the Conference Committee. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The bill will be returned to conference. Representative Long.
Madam Speaker, I move that Senate File 37 be taken from the table.
Representative Long moves that Senate File 37 be taken from the table. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The bill is taken from the table. The clerk will report the bill.
Senate File number 37, an act proposing an amendment to the Minnesota State Constitution, Article 1.
There is an amendment at the desk. The clerk will report the amendment.
Rarick moves to amend Senate File number 37, the unofficial engrossment. The amendment is coded A12.
The member from Wright, Representative Rarick.
Thank you, Madam Speaker. Before I get going on this amendment, I'd like to ask for a roll call.
Representative Rarick requests a roll call. Seeing 15 hands, there will be a roll call. Representative Rarick.
Thank you, Madam Speaker. It's getting very late, and I didn't want to forget. So, members, this bill came only through the Rules Committee for a hearing. That's it. Nothing else. In the Senate, it had many other stops. Here, one. And it was really stunning to me when we did have the hearing in Rules Committee, which we don't have many. It's not very often. But there was something that came up in the testimony from the public that was rather jarring. And my amendment addresses some of that concern. And as you read the language of the bill, Madam Speaker, can you quiet the chamber?
Members, please take your conversations off of the House floor into the retiring room or the alcoves, deeper in the alcoves. Representative Rarick.
Thank you, Madam Speaker. It's late. It's hard to hear myself think. Okay, so this amendment, as you read it, and it's just a 2-page bill to put a constitutional amendment on the ballot. It's not even 2 full pages. What's interesting to me is the language that goes before the people, the language that goes on the ballot. It's very short. I'm just going to go ahead and read it so we can all be on the same page. It's on page 2 if you want to follow along. Shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under the laws of the state, and shall not be discriminated against on account of race, color, national origin, ancestry, disability, sex, including pregnancy, gender, and sexual orientation. Now, I don't even remember exactly when we started the debate on this bill because it has been days. It's been days that we've been debating this. And we've debated many of the words that are on the paper that I just read. The two words we have not debated very much, almost none, is including pregnancy. Now, it seems rather innocuous, including pregnancy. And someone that was unaware of what that actually means might think, well, of course we don't want to discriminate against someone that's pregnant. The cute little grandma that goes to the poll, and there's lots of little grandmas and lots of little grandpas that go. Someone that isn't completely aware of what this language does will look at that and say, yeah, we don't want to discriminate against someone that is pregnant. But the fact of the matter is, it has very little to do with discriminating against someone who's pregnant. Because when you flip the page over, what goes into our state constitution is the words, making and effectuating decisions about all matters relating to one's own pregnancy, or decision whether to become or remain pregnant. And even in that, it doesn't use the word abortion. And so the language of the bill will enshrine abortion in our state constitution up until the moment of birth. It is the most extreme abortion laws in the entire United States and on par with some of the most extreme nations in the world. And we are enshrining this in our state constitution, the highest law of our land in Minnesota. The U.S. Constitution trumps that, but the highest law here in Minnesota. And we don't even use the word abortion. We don't even use the word. It's not in the bill. It's not in the language that goes before the people. And let me tell you what they had to say about this in the one and only committee that we had, the one and only hearing that we had in the House of Representatives, the only public vetting we had of this in the House of Representatives, and this is what some of the people had to say. Mohammed Ahmed said this: "We believe in democracy. We believe in democracy. And this will enshrine death culture. This will enshrine death culture in our Constitution. Don't fool the people." It's Mohammed Ahmed is who said that. Don't fool the people. This is enshrining the death culture in our very own Constitution. Another woman said, you need to actually include the word abortion in the language in front of the people. Of course you do. And yet here we are. In my amendment, it adds some of the language that will go into the Constitution on the ballot. It adds decision whether to become pregnant, whether to become or remain pregnant. Now, I would have liked language that went even farther, to actually include the word abortion. Now, this is what goes before the people is vague. And there's even, people have used words like deceptive. I'm not using that word, but that is what many people have said. It lacks transparency. So there was a college student that came, Ms. Falls from Minneapolis. And she said, this lacks transparency and it's deceptive. Young college student. She had to be 20, 21 years, maybe even 19. She was young. She was under 20. And she said, I want everyone that looks at this language on the ballot to know what they're voting for. Because right now they don't. And in fact, you know, this was actually when this language was discussed on at issue. I'm kind of an at issue fan. And Amber Reichgott-Young was talking. Now, she was a senator here, right? Some of us, not me, but some have served with her that are still in this body. And Tom Hauser asked her, well, it doesn't use the word abortion. How are people going to know that that's what they're voting for? You know, and instead of pointing to the language that is before us in this bill, her answer was this: well, there's going to be millions of dollars spent. I'm sure the public will know after all that money is spent. What a sad tragedy. We're not doing our job here at the legislature if we have to depend on outside organizations to inform the people what we're doing. What are we doing? We're not even using the word abortion, and we are enshrining the most vile, divisive, difficult, and radical abortion laws in the entire United States in our state constitution without even uttering the word. I knew that this was going to be a really difficult many days as we debated this. And we've heard some very difficult stories from particularly the women on this side of the aisle and a few from that. And I'm not going to go into the story of why I am unapologetically pro-life. I'm not going to go there. I have shared it before, but tonight is not the night. I'll just say this. When you've held your own baby in your hands and she takes her last breath, it changes a person. So members, like I said, I would like to have an amendment that went farther and actually included the word abortion that goes before the voters. And if you want to add other words, go right ahead. In vitro fertilization and all these other things that we're probably going to be enshrining in our state constitution as well, because it says all matters regarding pregnancy or to become pregnant. So the state might be responsible for all kinds of costs. But unfortunately, the only committee that this bill went through is the Rules Committee. We didn't go to a Health Committee. We didn't go to Ways and Means. We went to the Rules Committee, and then here. So I guess we're going to have that conversation here on this floor. Members, I would ask for your support on this amendment. And I know I've got several members that really want to speak to this because this is one of the most difficult things of what's in front of us. We are putting two completely different things on the ballot and just putting it all together. Abortion should not be put together with the ERA amendment. And you know how many people think that? About 68% of Minnesotans that were polled by KTSP. Channel 5, I'm very tired. The KSTP poll said 68% don't want it that way. They want some limitations, and they don't want those two to be together on the ballot. So members, I ask you for your support for this amendment.
Representative Long.
Thank you, Madam Speaker. So this amendment.
I was thinking you were going to talk about midnight.
Oh, sure, be happy to. Madam Speaker, the hour is late. I am getting tired, but I would like to keep going, and I move that we waive Rule 1.5 and let us meet past midnight.
Representative Long moves to waive Rule 1.5 to allow the House to meet past midnight. All those in favor, please say aye. Those opposed, please say no. The motion prevails. Discussion to the Rarick A12 amendment. The member from Ramsey, Representative Hur.
Madam Speaker, Representative Rarick, I just want to address really quick. I know that we've had a lot of conversation around that this was only heard in rules, and I want to be clear that this bill, that is the place that constitutional amendments are heard is in rules, and we did have a lengthy hearing in rules, and so that was the proper committee in which to hear this bill. I want to just state that the purpose of a ballot question is to summarize the constitutional language, and that is what the ballot question does. Pregnancy is more encompassing. It is not just about the decision to become pregnant or remain pregnant. It is also includes miscarriage care, postpartum care, lactation, just to name a few. So keeping the ballot questions just as it is in the underlying bill is actually more accurate, and so I recommend a no vote.
Discussion. The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Rarick, for this amendment. And Representative Hur, as you noted, there is a legal standard that goes into whether or not a ballot question is proper in Minnesota, and that legal standard has been litigated many, many times, and it's quite likely to be litigated again this year, and so I do have a question about that if Representative Hur will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker. Representative Hur, was there a fiscal note on this bill related to the potential for litigation against the state of Minnesota related to the ballot question?
Representative Hur.
Madam Speaker, Representative Scott, there is no actual fiscal note to this, and we actually, in none of the bills that we pass, put a fiscal note on based on the fact that we think it might get litigated because any bill we pass off of this floor could be litigated.
Representative Niska.
Thank you, Representative Hur. That's not correct. We frequently have fiscal notes on bills. We had several bills last year in which there were potential litigation risks to the state, in which we did have fiscal notes, and so it's pretty stunning that there was no discussion, no questioning, no request from the budget office about what the cost will be. But there will be a cost to the state because there will be litigation against the state, litigation against the Secretary of State, probably defended by the Attorney General's office about this question. And Representative Rarick is 100% correct. This is very, very poor, deceptive ballot language to tell the people of Minnesota that we're just about pregnancy discrimination when in fact it's much, much broader than that. It covers, I think as the testimony, as the advocacy has been, it clearly is meant to cover issues related to abortion, codifying into Minnesota law the most extreme pro-abortion policy in the country, probably the most extreme abortion policy in the world. Covers many, many other issues. I know that we're going to get into some of those issues further in this debate related to surrogacy, related to treatments for infertility. Just on the previous amendment, we I think, established that it's going to cover potentially spending decisions by the state in order to help with potential reproduction. We've had many bills come through this legislature this year about state spending or insurance company spending on things like infertility treatments. The idea that just having the word pregnancy on the ballot gives the people of Minnesota any idea about any of that stuff is frankly absurd. And so I do appreciate, Representative Hur, that in the hearing you took exception to the idea that you were trying to be deceptive. I don't think anyone is questioning your motives, at least not your motives personally. But the fact of the matter is this amendment is being brought to the ballot in a way that is not going to explain to the people of Minnesota what's truly going on. So Representative Varick, thank you for this amendment. It's very important, and I'm sure we'll have some further discussion about what actually is happening under this amendment and what the people of Minnesota should be told about it, but I urge members to vote yes.
The member from Goodhue, Representative Altenorf.
Thank you, Madam Speaker, and thank you, members. Thank you, Representative Varick, for bringing this. This is a very, very simple ask, okay? We want to make sure that when we're asking a question on the ballot, that it is very clear, and I think it is our duty to make it clear. That's what we're doing right here in this body. So my concern is right now in Minnesota, we do have a lot of citizens that English might not be their first language. English might be their second language. We have a large Muslim community, Hispanic, Latinos, and all of these communities typically are also very against abortion. And if the ballot is simply saying pregnancy, how does that translate in these other languages? How does that translate so they understand truly what they're voting for? This is not clear, members. This is not clear, and it's really not fair that we're doing this. As mentioned before, the KSTP poll, 64% of Minnesotans are asking that this question be two separate questions. One for the ERA, and then one for the pregnancy or, quote, abortion part of it. So, members, this is simple. We need to make sure that we're clear in what we're asking. In fact, I know when I've been in committee hearings, I have heard the majority party in instances say that we need to have plain language. I've heard those words. That we are in some instances saying that we have to have plain language so it's crystal clear, and yet something that is this important, we are now very vague. We are not actually telling the public, we're not telling Minnesotans what they're actually voting for, which is enshrining into our state law, into our Constitution, the most extreme, the most radical abortion laws in the country. Last year in 2023, you came out right out of the bat, number one priority, HF1, abortion to birth. That was your number one priority, folks. We all know it. You came out with it. We were voting on that in January. Now, by putting this into our state constitution, you owe it to Minnesotans to be crystal clear on what they're voting for. This is not right. This is not right, and the hypocrisy is thick. When sometimes you say that we need to use plain language, sometimes in committees you say we need to be crystal clear for our English second learners. Sometimes that's what you're saying. And now this is so vague that people of faith communities, of Muslim groups, of Hispanic groups would potentially be voting for something that they don't understand what those words mean. Members, we are asking for a very simple fix. And in fact, this is quite deceptive to the Minnesota public for us to not make this change. I know, Representative Herr, you said you wanted to use the word pregnancy because that was all inclusive. Then add the word abortion. Add the word. You cannot say in committees at one point that we need to use plain language, and in something that is this important, to now ignore plain language. Members, please support the Rarick's amendment. Please support this, And let's be crystal clear with Minnesota. You know, a lot of people don't like politics, and this is why. This is why, right here, members, people don't like politics because this is a sham. This is hiding behind the words. And we owe it to Minnesotans to be crystal clear on something this important that they're voting for, especially when we have faith communities that speak different languages that do not understand these words. This is very manipulative, it's very deceptive, and quite frankly, it's very disgusting. Be clear in your words, use plain language. This is not a difficult ask. This is not a difficult ask. Be clear in your words for Minnesota.
The member from Carver, Representative Nash.
Thank you, Madam Speaker. Would the author of the underlying bill yield to a question?
She will yield. Representative Nash.
Thank you, Madam Speaker. Representative Hurd, I want to make sure that I heard you correctly because it's late and we're all very tired, but did you say that the Rules Committee is where constitutional amendments are heard?
Representative Herr.
Madam Speaker, Representative Nash, yes.
Representative Nash.
Thank you, Madam Speaker. Representative Herr, if she would continue to yield.
She will yield for another question. Representative Nash.
Thank you, Madam Speaker. Representative Herr, are you familiar with House File 4598? It is Representative Long's constitutional amendment for Re-elections Commission, and I believe he called it Good Government Bill.
Representative Herr.
Madam Speaker, Representative Nash, I am familiar with it, but I think maybe you might want to ask Representative Long about those questions.
Representative Nash.
Thank you, Madam
I'm
Speaker.
sure you're going to relate this to the 812 any second now.
We're getting there, Madam Speaker. You know that I'm more than capable of doing this. So, well, Representative Herr, I'm going to remind you that this was heard, the Majority Leader's bill, House File 4598, was introduced on and then referred on 3-7 to elections. And then on 318, it was in state and local government, where you serve on that committee. We were in the committee that day. So we heard the constitutional amendment in state government finance, and I have to think ostensibly it was also heard in elections finance committee, and then it made it to rules. So your supposition that constitutional amendments are only heard in the rules committee is wrong because you participated in the debate relative to Representative Long's good governance elections bill. So I just wanted to set the record straight that, once again, this was not a properly vetted bill, not properly pathed bill. We heard it in rules. It was very brief, and there are 16 members in rules, only 16 members. And I'm just wondering why was that skipped? Why was this particular language? And there was a version of ERA that was heard, but it's not this language. This particular language was never heard in state government finance. If she would yield to a question and affirm that.
She will yield. Representative Herr.
Madam Speaker, Representative Nash, and thank you for bringing that up, because I do just want to clarify that Representative Long's bill, House File 173, was heard in March of 2023. It was amended and then heard in rules. Same thing with this bill. This bill was actually heard in State Gov last year, and then it was amended, and then it got heard in rules. Same path, same process, same situation.
Representative Nash.
Thank you, Madam Speaker. Well, let's be very clear. Representative Herr just said a bill was heard and then amended and then heard in rules. So the language in this particular bill were not heard in anything other than rules. Once again, we're trying to hide things by saying, well, a version of this, a thing that says ERA on it, printed on paper, was delivered to a committee and then
Point of order,
done
Madam
so.
Speaker.
Representative Herr, please state your point of order.
Representative Nash is impugning my motives. He's saying that I was trying to hide something in the process. The process was very transparent. It actually went to the committee, was amended, and then heard in rules, just as the bill that Representative Nash is referencing. It was amended after leaving State Gov, and then it was heard in its final form in rules.
The point of order on motives is appropriate to interrupt the speech for, and Representative Nash, if you can just say words that express your meaning but don't impugn motives, that'd be great.
Well, Madam Speaker, I never impugned motives. I merely pointed out that the exact language of this bill were never heard in state government.
That's okay to say, but saying tried to hide.
Morphologically, they are two completely different bills. The
Representative
language on-
Nash.
Thank you, Madam Speaker. The language on the two bills morphologically is completely different. So add that to your lexicon there, guys, morphologically. So once again, I'm just pointing out that it is a vastly different bill. I'll share it. I'll text you. It is a vastly different bill. It has not the same exact language, and as a result of that, it cannot be claimed that this bill, in its current format, was heard in anything other than rules. Thank you, Madam Speaker.
I have on the list, but I'm sure I'm missing somebody, Dotseth, Hudson, and Scott. So yes, Bennett, you were before some of these people. The member from Freeborn, Representative Bennett.
Thank you, Madam Speaker. Appreciate it. Members, the language that's in this underlying bill, the ballot language, in regards to pregnancy, is a Trojan horse. And Representative Rarick, thank you for this amendment, because people deserve pregnancy. People, okay. Let's start that over again. I'm really tired. Yes, we deserve pregnancy. No, all right, I'm gonna start over. Oh my goodness, okay. This language is a Trojan horse in that it uses pregnancy when it really means abortion. And the people of this state deserve more. They deserve to know what they're voting on and what it really means. Everybody deserves transparency. And you know who especially deserves this transparency? The persons in this state that have no equal rights. And we've been talking about a lot of equal rights tonight. And I'm talking right now about the child in the womb. I think of baby Everett, Representative Engen's little boy. He was born, a little over 6 weeks ago, I believe. Baby Everett right now in the hospital, growing, or praying that he's continuing to grow strongly, has all the equal rights that we all have. But a little over 6 weeks ago, he didn't have any rights, and especially the most precious right to life. So that baby and those babies in the womb deserve the transparency in this language that allows the people of Minnesota to know exactly what they're voting for. And that when the word pregnancy comes up, it's really talking about abortion and other things. But as the bill author stated, pregnancy means a lot of things in this bill. And people deserve to know that they're talking about abortion. And the most extreme abortion laws enshrined into our Constitution, if this were to be voted through, more extreme even in the United States, but in the world. So it blows my mind that as a society, we will protect eagle's eggs, an eagle embryo that will hatch out and become an eaglet, and we know it's going to be an eagle, or we will protect turtle's eggs. That's an embryo that grows up and hatches into a hatchling, I learned. And yet, the one who deserves the most transparency in this language doesn't get any rights. You know, when I taught first grade for those many years, that's 6- and 7-year-olds, and I would look into their eyes, and I would see all their excitement and their imagination and their exuberance for life, and I would think, which one of you would not want to be here? And you know what? They all would want to be here. They all deserve those equal rights, even when they were in the womb. So for all those babies in the womb now, all those babies who will be in the womb in the future, let's give them the transparency they deserve. Let's give Minnesotans the transparency they deserve so that they know exactly what they're voting for. And that is to enshrine in our Constitution the most extreme abortion laws in the world. Thank you, Madam Speaker.
The member from Carlton, Representative Dotseth.
Thank you, Madam Chair, members. You know, one thing I've learned is the power of words. Thank you, Representative Rarick, for clarification of the power of words. Where I come from, our word is our word. Our word is good, and it's clear of what we stand and where we stand for. I, too, am unapologetically pro-life. You know, as a father's perspective, I'm blessed to be a father, a husband, and a grandfather. I go back to 1998. Found out that my wife was pregnant. And after a prior situation where she had a miscarriage. The prior child. You know, it doesn't just affect the mother, it affects the father as well. It's a traumatic thing that happens to you. But 1998, she was pregnant. Found out that early on that it was going to be a situation where they encouraged to actually terminate the life of the baby. We chose to do what it took to keep that baby alive. My wife was on bed rest for majority of the pregnancy. January 22nd, 1999, my baby girl was born. If we would have made that decision, she wouldn't be here today. Married. She just raided my freezer, deep freeze yesterday. So it, you know, the things your father, as a father, you care about your kids. In the last 3 years, I've seen a lot of smoke and mirrors in our state, in our nation. But what I've witnessed here in the last year and a half, 2 years at the Capitol, it's unbelievable. Your word needs to be your word. It needs to be good. It needs to be clear. You know, we're speaking of this ERA. This isn't my grandmother's ERA. This is a whole different bill. You know, we spoke of the days of Hubert Humphrey, and those times I actually once passed out literature for Hubert Humphrey. Yeah, a Republican passed out literature for Hubert Humphrey. It's a whole different scenario now in the state of Minnesota. At a time where we're seeing extreme abortions all the way to birth, rights of our elderly at stake, how come no one's talking about this bill affects our elderly as well? I got a 92-year-old Korean War veteran father-in-law. I just was at the other day when we actually had a break from recess here. He's got value. He's still living in his own home, on his own. You know, he's getting a little more frail. And we're currently considering actually moving him up to our home. But at that same thing, you still got to look at, he still deserves the dignity. He served our country, fought for our country. We need to preserve and protect those lives. The most vulnerable. I mean, that's at stake right now, too. There's a lot more to this ERA bill than what people are looking into it as. It's not the same bill that some of these people up top thought that they fought for years ago. I just pray that we come back to a moral compass in our state and just pray that the fear of God comes back upon each and every one of us and look at the consequences of what we're passing here. You know, the members across the other side of the aisle, a lot of us disagree on different items, but you know what? I still love you. I don't look at you as an enemy, but we may have different views and perspectives, but just don't try pushing this stuff on my family. What you do with your life, I don't care. But just don't have it where it's going to affect my kids, my grandkids, my father-in-law. That's all I ask. That's what I was elected to do, is to protect and preserve and protect those people. At the end of the day, I'll just close in this. I just ask that you come to a heartfelt decision on what you're doing. You know, I understand that you believe you're doing what is right. There's a lot more to this, and there's a lot more consequences with what we're doing. I ask you to vote yes for this amendment. It puts some guardrails in place that we need. And vote no on this bill. Thank you.
The member from Wright, Representative Hudson.
Thank you, Madam Speaker. Members, I'll recall your attention to just a few days ago, although at this point it feels like it could have been a couple of weeks. We spent several hours on this floor talking about cheeseburgers, as I recall. And the item under consideration was deceptive trade practices, false advertising. It's really super duper important that when someone makes the decision to purchase a hamburger, that they know exactly what it is that they're getting and exactly what value they're exchanging in return. Because we certainly wouldn't want somebody to think, going in, looking at a sign on the side of a storefront, that something marked as $12.99 was actually going to end up costing them $14, $15, a couple bucks more. Really super duper important to make sure that things are advertised just right. I'd like to appeal to that idea, that concept. Only in this case, the transaction that we're talking about is, do you want to fundamentally transform your government? Stakes are a little higher. And certainly if it's important to know exactly to the penny how much I'm going to pay for a cheeseburger, it's probably important to know exactly what it is that I'm going to get if I vote for this amendment on the ballot. And as it currently stands, I mean, you know, right now this amendment, we're focused on these two words, including pregnancy, but this whole thing could use a rewrite. I mean, I don't want to give a third reading speech here over an amendment, but just to tick down the items. Maybe we'll put it in context first. So again, the ballot question reads, shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under the laws of the state and shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, real quick there, including pregnancy, gender, and sexual orientation. Now, I would argue, and I think a lot of folks would argue, that when you take a look at the actual impact of what the underlying proposed amendment to our state constitution does, that doesn't come close to describing it. You're talking about an amendment that is going to erase the category of women as such in law. We had ample conversation about that last night. You're talking about an amendment that, you know, I've been learning as I've been listening to Representative Niska talk through the legal implications, that's going to effectively take away Democratic representation in a couple of different ways. It's going to turn the jurisprudence of our state, the policy setting, the rulemaking, the lawmaking, the legislating of our state over to lawyers, judges, activists, whoever can cough up enough money for the lawyers. It's going to encroach upon our religious liberty. It's going to cancel our freedom of conscience. Article 1, Section 16 of the Constitution will be completely meaningless after this thing passes. And of course, the question at hand. And this is the first time I've had to really put a point on it, a fine point on it in this chamber, in this setting, but I just want to be really super clear about what we're talking about here. The effect of this amendment, if ratified, is going to be for, I believe, the first time in the history of the state, to change our founding document, our highest law of the land, for the purpose of stripping civil rights from an entire category of human beings in perpetuity. That's what it does. It says that if Everett Ingen, who even to this date was born at 28 weeks, it's been 45 days, he hasn't hit that 40-week threshold that's generally considered to be full term, but nobody, not a single person, there's not anyone who denies that that's a human child. But if he had a change of address, if he was still in the womb, the exact same human being, exact same characteristics, same nature, he would be eligible for termination. And by the way, that's under current state law. See, what I'm describing here, you've already done. You've done it in statute. This isn't something that is gonna happen if this is ratified. This is something that you've already done in statute. If this is ratified, it just makes it permanent. We've already stripped civil rights from an entire category of human beings in this chamber, which is a remarkable thing to consider an accomplishment. And now we're considering making that permanent for perpetuity, for all time. We're gonna look at an entire class of human people and say, we are not even gonna acknowledge your existence. And we're gonna allow anything to happen to you with no regard for your inherent value. I think that might deserve a little bit more than including pregnancy in the ballot question. And we're not offering, some dissertation. The replacement phrase would be the decision to become or remain pregnant. Just adding a little bit more specificity on what it is that we're talking about, so that people know when they go to the ballot that they are voting to permanently strip civil rights from the unborn up until the very moment of their birth. I think that is advertising that should not be false. Thank you, Madam Speaker.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker. Would the author of the bill yield for a question?
She will yield. Representative Scott.
Thank you, Madam Speaker. Representative Herr, you ran through a list just a little bit ago of the what pregnancy under this law or this proposed constitutional amendment could mean. I think you said like miscarriage care, there were some other things. And I just wondered if you could go through that list again if you have it written down.
Representative Herr.
Madam Speaker, Representative Scott, I listed just a few of what pregnancy could include because I don't think I could ever come up with an all-encompassing list, but it does include, what does include miscarriage care, postpartum care, lactation, just to name a few. So I just named a couple of them, but pregnancy does include those things and more.
Representative Scott.
Thank you, Madam Speaker, and thank you for answering that question. Would Representative Herr yield to another question?
She will yield. Representative Scott.
Thank you, Madam Chair. Representative Herr, so I agree with you. The statement is really broad, including pregnancy could include a lot of things. Does this limit the state's ability to regulate and pay for surrogacy and fertility treatments? Could those be considered pregnancy under this definition?
Representative Herr.
Madam Speaker, Representative Scott, I hope so.
Representative Scott.
Thank you, Madam Speaker, and thank you, Representative Herr, for answering those questions. We had a pretty significant debate a couple weeks ago on surrogacy in this body, and right now it's the Wild West. And actually, the bill that was offered was also the Wild West as far as surrogacy. This will not change that. In fact, it might just be decided just by a bunch of courts and judges, not the legislature. Part of the problem with this whole amendment is we're abdicating our responsibility to the courts in a big, big way. So rather than proposing that we have a full-time legislature, we may not even need to be here maybe every other year, because everything's going to be decided in the courts. This is such an all-encompassing fruit basket of a constitutional amendment question. So thank you for the honest answers. I think we've got it on record that this could, and again, the public needs to know this, but this could and probably will mean that the taxpayers are going to be most likely on the hook for fertility treatments. And then surrogacy will be just whatever anybody wants it to be. And then we get into the baby selling and the womb selling. Please, please support the Rarick Amendment.
The member from Clearwater, Representative Grossell.
Madam Speaker and members, I look at the submission to the voters, the part that'll go on the ballot if it goes there, and having read statute for quite some time and being familiar with making sure that statute is clear, and I've known my colleagues, the majority of them, talk about having clarity, making sure that statute is very well understood. That everything that comes out of this chamber should be clear to whoever's looking at it, and to be able to articulate just what it means. And as I look at this this piece here, it's not clear. It's not clear. So if I were looking at this and being very, very pro-life as I am, I would probably vote yes to put this into the Constitution. Because, of course, I want equal rights. But then again, we all already have equal rights. Every person in this chamber has equal rights under our Constitution, has equal rights under our human rights statutes, everything. So in all actuality, this ERA amendment is not needed because we're there already, folks. We have equal rights, all of us. No matter what your orientation, sexual orientation is, no matter what your race, religion, we have equal rights. Now, I've worked hard to try to make sure that legislation that I put forward is also goes along with my faith beliefs. To make sure that that legislation, when I line it up with God's word, that it is a best reflection that I can have in front of me, that I can give to people, that I can share. And I know God's word is not confusing. It's not confusing. I know God's word is clear. But when I look at this does not, the submission to the voters is not clear, so therefore, it would not line up with God's word. To me, it would not line up. Because there's vagueness in there, there's a part in there that's being left out. That would be put into our Constitution. And it's something that I could not support, I would not support. And I know Representative Herr has worked hard to make sure that when we're reaching across the aisle, working across the aisle, that does the best job that she can to make sure that things are done right. I know that. I've already seen that work being done. But the vague reference to pregnancy in this submission part, in the ballot question, to me is misleading and unclear, leaving voters uninformed about the true implications of the amendment. We all deserve, people deserve to know what they're voting on. And the way the ballot question is written, to me, is deceptive and does not tell the story of how expansive this new language would really be. Now, that is not questioning anyone, especially the author, because I know the work the author has done. That is not questioning the author's integrity at all. It is just that when a reasonable person looks at this, there's something missing here. And again, this language be added to the Constitution to enshrine the most extreme abortion policy in the nation and the world. Abortion up to the moment of birth, which most Minnesotans, about 64%, do not believe is right. Now, if this is clearly written and it is on the ballot, then okay. But make sure that it's clear. Make sure that what we do here, like God is not a God of confusion. God does not hide things from us. Makes it very clear to all of us. So I ask that you again, like I said before, we all have equal rights right now, already. We all have equal rights. This ballot question is not even needed. Senate File 30, SF 37 is not needed. But I would at least ask you, if you're going to pursue this, take the amendment. Let's make sure it's clear. Let's make sure there's a very good picture of what people are looking at. Please support the amendment.
The member from Anoka, Representative Engen.
Thank you, Madam Speaker. After we adjourn tonight, I'm going to go and sleep on a cot at Children's here in St. Paul. It'll be a dark room, just myself and my son, who should still be in the womb, according to modern medical science. He's not at full 40 weeks gestational age. He's breathing on his own. He's eating on his own. He gets fidgety. He has all of the characteristics of a person who thinks. He feels things. When my hands are cold and I put my hands on him, he swats my hand away. And I run cold, so I always feel bad. I have to go run him underneath the sink and warm him up for him. He opens his eyes. He looks at me. He looks at the mobile that we hung above his crib. He's a person. And he's 34 weeks old today. 34 weeks, 1 day. If you're going to say that he doesn't have the fundamental right to exist. He can be ended. At least have the gall to say it. Because as I read this language, if I didn't read the rest of the bill, if I just saw the submission to voters, I'd want to vote for it. My family would want to vote for that. We don't want to discriminate against somebody because they're pregnant. But then you read the bill. On page 1, line 18, making and effectuating decisions about all matters relating to one's own pregnancy or the decision whether to become or remain pregnant. We're using your own language, your own definition in this amendment. That shouldn't be too much to ask. Clarity matters. Transparency matters. We represent people. We shouldn't try to mislead them. And I don't want to say that that's what you're doing, but that's what this does. It's what's been done in other states, and I'll give you kudos. It's been very effective there. Other states have passed this language overwhelmingly, and it's been pointed to and people say, ha, see, they do want it. And then you have a slew of people who come out a day, a week, a couple weeks later, they say, I didn't know I was voting for that. Please, just tell us what you believe so that people can vote for it or against it, but make it transparent.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker, and members. One of the things that has really bothered me about this unequal rights amendment is the lack of clarity in the language. Because, of course, in the actual constitutional amendment that's proposed, there are a lot more words than what is going to go on the ballot for voters. And frankly, this language, particularly regarding pregnancy, is really misleading, particularly when you think of the history of women in the workplace. I suspect is what the vast majority of people will think of when they see the language, including pregnancy, that women shouldn't be discriminated against based on pregnancy. Every woman's mind is going to go to the history of women in the workplace and acts of discrimination against women, either not being hired for jobs because they are pregnant or could likely become pregnant, not receiving the same opportunities as men because they are pregnant or might become pregnant. That's what the average voter is going to think about when they see that language. Well, no, of course women shouldn't be discriminated against based on pregnancy. Of course not. Which is true. None of us think that should happen. None of us think that that should happen. And it's just a more honest way of dealing with the public to say, instead of just including pregnancy, the decision to become or remain pregnant, which is exactly the language you want to enshrine in the Constitution. If that's the language you want to put in the Constitution, then that's the language you should put to the public. Let them vote on what you are actually putting in the Constitution. Because it may not be your intention to mislead, but the language misleads. It is not honest. And I also find it very interesting that we are hearing a lot of unknowns as we go through this amendment. We've had a lot of questions for the bill author about what different things mean. And we get a lot of, I don't know, maybe, it's a hypothetical, I hope so. When it comes to surrogacy, I hope so. And if the author of the constitutional amendment does not know what this constitutional amendment is going to mean for Minnesota, then perhaps we should at least make the language that is being presented as clear as it can possibly be. This is just one step in doing so because I mean, we've addressed a number of issues that are not clear, that we have not gotten answers for here in this chamber. But this is at least an opportunity to clarify that pregnancy is not talking about discriminating against a woman, not hiring her for a job because she's pregnant. That's not what this is talking about. This is talking about putting the most radical abortion policy in the world into the Constitution. That's what this language is about, so let's say that. This is about and in fact, we don't even say that. The proposed amendment is not even clear on that. The proposed amendment just takes your own language and puts it to the voter. The decision to become or remain pregnant. Why would we shy away from that? Why would we shy away from that? Is it because, I mean, I'm concerned. I'm concerned because the result of ambiguous language is poor decision making. When people don't have all the information they should have, they're unable to make good decisions. And interestingly, I suspect many people saw it. KSTP had a poll. I don't know, I've lost track of days. Was that just this week? Last week? I forget. Just this week. Just this week, KSTP released some poll results that 51% of Minnesotans do not believe that abortion should be in the Constitution at all. Over half of Minnesotans do not believe that abortion should be in the Constitution. And yet, the language that we are putting to the public, the language that we are giving to the voters, does not express to them that pregnancy means abortion. The language that we are giving to the voters is dishonest. Because if 51% of the voters knew that this language is about abortion, they would vote no. And what's the other number? 61? 64? 64. 64% of voters do not believe that the Equal Rights Amendment and abortion should be combined into a single constitutional amendment. 64% of voters do not believe that these two things should be tied together in the Constitution. 64% of voters. But frankly, if all a voter sees when they go to their ballot is, let's see here, race, color, national origin, ancestry, disability, sex, including pregnancy, gender, and sexual orientation. Okay, pregnancy, that's fine. They have no idea what they're actually voting on. They have no idea. This language is so dishonest. It lacks all transparency to the voter. You are asking voters to change the Constitution of the state of Minnesota. And you are not telling them the truth about what the amendment actually does. That is so dishonest. So the Rarick Amendment that simply changes the language of pregnancy to the decision to become or remain pregnant at least offers a little clarity, a little transparency on the decision people are making to change the Constitution, which will become the highest law of the land in our state, which will supersede any state laws that we write. Changing the Constitution is so consequential that we should take every precaution to make sure that voters have all the information they need to make an informed decision, to know what they are voting on and not just what the Democrats decide they get to know. Because this information limits their knowledge, and it is not right. This is not a good way to do business. This is not a way to deceive voters into voting for something that we know 64% of Minnesotans believe is a bad idea. They do not want to see these things on the ballot together. 51% of voters would vote against if they knew that's what this language means. But by tucking this in to the Equal Rights Amendment and just calling it pregnancy, we are deceiving voters. Because if we told them it was abortion, 51% would vote no. If we told them it was abortion and they understood it was tied to the Equal Rights Amendment, 64% of Minnesotans would vote no. This is so wrong. It is so dishonest. Take the Rarick Amendment and give some transparency to the people of Minnesota.
The member from Crow Wing, Representative Davis.
Thank you, Madam Speaker. Yeah, so I just want to read this quickly, and I know many have already read it, and I'll try not to be too long, but making and effectuating decisions about all matters relating to one's own pregnancy or decision whether to become or remain pregnant, but that's not the question that'll be on the ballot. The question on the ballot: shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under the laws of the state and shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, gender, and sexual orientation. That's the only thing the voter will see on the ballot, including pregnancy. So just thinking someone gets pregnant, yeah, they should not be discriminated against. That language right there, I read that, if I didn't read this whole thing, if I just read that, I would be deceived about the question on the ballot. And this ballot question, there'll be, if this makes it to the voter, there will be people who will vote yes for this, and then afterwards, if they actually looked it up, they would go, oh, I was deceived. Why would we do that? Especially when the intent of it is regarding abortion, ending the life of a human being in the womb. Think about that. They have a heartbeat. They have feeling. And don't tell me they don't, because my wife's been pregnant a lot, and we know they have feeling. We know it. And I know they have pain. My wife knows that too. They have pain. They feel pain in the womb. And boy, a baby will let you know when it feels pain in the womb. And this one too, and you might think this is ridiculous, but I know it's not. They communicate with their mother while in the womb. And many of you women in this room, you know what I'm talking about. And I can't really explain that one to you, but you know it. Somehow, some way, they communicate certain things to you. That human being in the womb. They have a heartbeat, they have feeling, they have pain, they communicate, and science proves that they have thoughts. And they get their oxygen through their mother. What a beautiful relationship between a mother and a child in the womb. What a beautiful relationship and dependence upon life between a child and their mother while they're still in their mother's womb. And I've heard testimony of people that have worked at abortion centers where they actually saw on the ultrasound while an abortion was being done that defenseless little human being, that defenseless little child fighting and struggling for their life while the abortion was going on. And we're just going to put a question on the ballot. Don't discriminate against pregnancy. This language is very deceptive, and I'm probably not allowed to talk about on this House floor why, because I'd be impugning motives or something. But boy, I do have that question burning away in my heart, and my heart can't help bring up a bunch of answers. And they're not good. Why would we do this? This discriminates against children, babies, defenseless human lives. This discriminates against them. This is the most discriminating thing I can think of right here. This question on here, this bill for this amendment. We're discriminating against human beings to have the right to live. We're going to enshrine that in our, try to enshrine that in our Constitution. We got to change this. Again, I don't support this underlying bill, but I certainly do support this amendment. Thank you, Representative Rarick. For the sake of defenseless human beings in the womb, babies, children, let's light that board up green. You did ask for a roll call at the beginning of this, didn't you? Let's light that board up green, and I'll end with this, and then I am going to be done. I've already spoken longer than I thought I would. Again, I believe this is a voice coming from the womb. For you created my inmost being. You knit me together in my mother's womb. I praise you because I am fearfully and wonderfully made. Your works are wonderful. I know that full well. That voice is speaking of God. And it sounds like to me in Psalm 139:13, that very well could be a voice speaking from the womb to its maker. Thank you, members. Please, let's light that board up green.
Representative Rarick.
Thank you, Madam Speaker and members. We started this debate days and days ago, and one of the first things that was said was that we've been working on this for decades. And way back when, many days ago now, we had a DE. Leader Damath brought forth the DE, and that was what was worked on for decades. That was. This is not. This language is nothing like what our grandmothers fought for, what our mothers fought for. This is not that language. This is not my grandmother's ERA. This is not my mother's ERA. This is not my ERA. This language, if passed and goes into our Constitution, would enshrine the most extreme abortion law in the entire United States and be on par with some of the most extreme communist countries in the world. I ask you to support me in this amendment so that we can at least let the people know just a glimpse of what they're really doing. And support my amendment, the A12.
The clerk will take the roll on the amendment. Will the clerk please call the names of the members voting remotely?
Acom.
Acom, no.
Acom, no. Carroll.
Carroll, no.
Carroll, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Wolgamott moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A23.
The member from Sherburne, Representative Wolgamott.
Madam Speaker, I rise as a proud ELCA Lutheran, a former church council member, and a longtime Sunday school teacher to present the A23 amendment, which would add religion to the list of identities and classes protected by the proposed Equal Rights Amendment. Madam Speaker and members, I've heard from previous discussions talk of other protections for religion in our state constitution, but we need to take a belt and suspenders approach to protecting Minnesotans from religious discrimination now more than ever. According to the FBI, anti-religious hate crimes have increased by 30% between 2021 and 2022. Nationwide, there have been 324 incidents of violence and vandalism against Catholic sites since 2020, and there were more than double that amount against the Jewish community in 2022 alone. And in my home community of St. Cloud, Islamophobia has reared its ugly head. We've seen troubling incidents of vandalism against local mosques, specifically at the Islamic Center of St. Cloud, which I know you've been to, Madam Speaker. It's a very sacred, very special site in our community, and unfortunately, we've seen it under attack based on religious discrimination. Again, members, we need a belt and suspenders approach to protecting Minnesotans from religious discrimination. That's why I'm bringing this bill forward, this amendment forward. I ask for your green vote.
Discussion to the amendment. Representative Nash.
Madam Speaker, before I begin my own debate, I would request a roll call.
Representative Nash requests a roll call. Seeing 15 hands, there will be a roll call. Representative Nash.
Thank you, Madam Speaker. I support the Wolgamott amendment, and I was informed that apparently mine is so much like it, it's going to get ruled out of order, so I'm going to speak as if this was my own amendment. We have all gotten a lot of emails and outreaches on this, and Representative Wolgamott, you mentioned some of the things that concern me as well, and I have been tracking the number of different religious beliefs that have reached out to me. And here are a few, because I think that many would like to believe that this is simply a bunch of evangelical Christians, of which I am one. I am proud to say that I have Jesus Christ as my Savior, and I believe that I am entitled to protection under an Equal Right Amendment, but we'll come back to that. But I think that many people would like to think that this is just Christians who are raising up a fuss over this, but I will tell you from the emails that I have gotten, they're not. So I looked and I talked to a number of them. I got a great number of emails from folks who follow Islam, Judaism, Buddhism. I got a few. I got several from who are practice the Mormon faith. I will take you to a conversation that I had with a person who used to be an Amish Anabaptist, so they are Baptist. There are atheists, Buddhists, folks who follow Shintoism, Sikhism, and Rastafarianism. I got one, so that was good. I agree. And it's not just Christianity, it's not just Catholics and Lutherans, and it's a huge selection of people who are people of faith who want to know that they are a protected class, as Representative Wolgamott said as well. And I'll take you back to when we began the debate, and I asked, I think I had the first question of Representative Herr, and her answer was, I would like to think, Representative Nash, that everybody would be equal under the law, but, and that's where I mentioned the but is an ellipsis for me, but they're not. And the rationale as to why we're having to have the Wolgamott amendment on this is still a mystery to me. So I guess I would like to ask Representative Herr if she would yield to a couple questions, Madam Speaker. Sorry, I don't ever usually do that.
She will yield. I don't get to be on any committees, Representative Nash.
I rarely do that,
Nash.
Madam Speaker, and you know that it bothers me, so I hate when I slip up. But thank you, Madam Speaker. And Representative Herr, Representative Wolgamott asked mentioned or alluded to one of the questions that I have, and it's effectively anti-religious voices and activists are more and more on the rise, and they're getting louder every day. Is it your legislative intent that protecting people against religious discrimination is not a compelling government interest?
Representative Herr.
Madam Speaker, Representative Nash, I'm going to repeat what I said yesterday because that is still true today, that religious liberties are already protected within our state constitution. It is stated in our preamble that religious liberty is it's a core to our Constitution, and in Section 16 and Section 17, religion is protected. It has some of the highest protection in our country.
Representative Nash.
Thank you, Madam Speaker. Well, I guess, and I'm sure you've caucused this, I'm sure you've talked about this, and I am encouraged that Representative Wolgamott has the guts to stand up and say that he disagrees with you on this. And I will be voting yes, Representative Wolgamott, and I would encourage all of my colleagues to do so as well. But let me ask if Representative Herr would yield to another question, Madam Speaker.
She will yield. Representative Nash.
So let me take us down this path. Representative Herr, is it your intent that gender identity should receive more constitutional protection under ERA than religious practice? And I'm asking, relative to your ERA proposal, why is religion not in there, and why does it seem that gender identity would receive more protection under ERA than religious practice?
Representative Herr.
Madam Speaker, Representative Nash, no one receives more or less. They all will receive strict scrutiny. Religion is already protected under our state constitution.
Representative Nash.
Thank you, Madam Speaker. Well, I'm going to take us back to what I just reminded the body of just a minute ago, because you said it yesterday. I, Representative Nash, would like to think that everybody was equal under the law, in your words, but, my ellipsis, apparently they're not. Apparently they're not. So, to Representative Wolgamott's point, apparently my heartfelt religious beliefs are not worthy of being included in the ERA, and I'm deeply confused by that. Why religion is not considered a protected class. in ERA. And I have listened a lot. I'm an attentive listener, and I write a lot of things down. And I hear regularly all about DEI, diversity, equity, and inclusion. Well, guess what? This is neither diverse, this is not equitable, and it is not inclusive if you are leaving religion out of this. Practice what you preach, put religion in, and show that your legislative intent is to provide a good level of protection for heartfelt religious beliefs as a protected class. I am very, very confused by this, and I am glad that I can provide you comedic relief, Representative Herr, as we laugh in this debate. I don't see why in something that is titled an Equal Rights Amendment, why you would I don't know what your intent is with Representative Wolgamott's amendment, but why would we not include religion? Because you've included a great many other things, and in debate yesterday, it felt like 3 days ago, but in debate yesterday, you also had mentioned other things in other parts of law that are covered, but you're putting them in here because you want them to have extra protection. Well, here's your chance. Here's your chance to say, you know what, belt and suspenders, Representative Wolgamott said, belt and suspenders, let's do that. It's simple. It's simple. Representative Wolgamott is merely inserting the word religion after a comma. Woo! That's tough. That's hard. I sounded a little bit like Ric Flair there. I know. Sorry. It's a simple process. You can do this without any difficulty. You just push the button green, do the belt and suspenders pathway. But I'm confused because the legislative intent here seems to be that you don't think that we should be included. Now, let's get back to Jim Nash. When I was 14 years old, I accepted Jesus Christ as my Savior. And I will tell you that that is a pivotally important thing in my life. Earlier today, we talked about some things, and I'm not going to get into it because I don't want to fall apart again, but it is only because of my faith in Christ that I was able to make it through all of that hell that I lived as a kid. And I would like to think that my own state of Minnesota here would recognize that that faith of mine that is so vitally important should be a protected class. And we've already seen in recent legislative time, that in the lawsuit that Crown College and others are involved in, that there is a decidedly anti-religious bent of our own state. So as somebody who represents the Crown College as a trustee, I would like to think that now my own state would say, well, we're going to make this a protected class. Stand up and do the right thing and say, people who are of great faith, and I listed off a great many of them. I can list more. I left out Jainism. That was another person that I tracked down. It's such a fundamental thing. And I'm confused by the legislative intent because it seems to be decidedly against people of faith. That the exclusion in this amendment that you wish to put on the ballot would say people of faith don't matter. That people of faith are not worthy of being a protected class. Incredibly troubling. Because as I drive through Carver County, I know a lot of people who are of deep, meaningful faith. Great Catholics and Lutherans and Baptists. People of all types of different faiths. Jews in my area, they're very concerned about this legislative intent that seems to be being created, that folks who are of these faiths are not worthy of being a protected class. So Representative Wolgamott, you have my guarantee I'm going to be voting green on your amendment. It seems like it's a practical thing. It doesn't seem like it's a difficult thing at all. It seems to me very common sense. And I would hope that for as many times as I have seen your caucus band together with you and others on amendments, that they would do the same. Vote green.
The member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. Members, I rise in opposition to the amendment, and I want to first get this out of the way that as with Representative Nash, I recognize the leadership of Representative Wolgamott. You stand on principle always. You fight for your constituents. I know that you're doing so now as well, so this is not any disrespect to you, sir. Having said that, what I'd like to ask, it's 1 in the morning, but if folks could please look for your blue state constitution. If you're watching online, we may have some folks doing that. There's been a lot of references to our state constitution. I think folks, as you're doing that, I think we're pretty familiar with our U.S. Constitution, so maybe we'll run a little quiz. Think, where is our protection of our religious liberties in our U.S. Constitution? It's in our First Amendment. Hopefully it makes sense to folks. The right of our free exercise. That is a federal constitutional right, very important. Of course, this amendment would not touch that federal constitutional right. I'd like to ask, as you bring out that blue book, if you can identify, we've said it a whole bunch of times in the course of this, as to where your state constitutional right to religious liberty is. Where is that? That is in Article 1, Section 16. We're less familiar with that, though maybe folks have been following along. If you could turn to that, folks, I would appreciate that. It's on page 4 of the blue book, and folks looking online, you can Google this, of course, at 1 in the morning. That's still available to all of us. And if you look, the right of everyone to worship God according to the dictates of his own conscience shall never be infringed. That is the language of our state constitution, not touched by this amendment. And nor shall control of or interference with the rights of conscience be permitted. Control of or interference with our rights of conscience shall not be permitted. That's in the state constitution, not touched by this amendment. And members, and there's reference to religious tests. Representative Hur at various points has alluded to this. Now, so have that in mind. That's very, very detailed. You compare that to our amendment we're proposing, fair enough. I'd like you to look in that amendment then. Representative Hur has pointed this as well. Lines 2.7 to 2.8. People may not have copies of this, but hopefully you got that online. That this amendment does not limit or narrow existing rights in this Constitution. Does not do it. At various points during this debate, I've heard folks say, oh, this is going to be eliminating rights, destroying rights. The very words of the amendment that will be before us once we make it through these amendments, the very words of the constitutional amendment make clear this does not limit or narrow existing rights in this Constitution. So let's make sure we're very clear on one thing, which is that we have religious liberty under our state constitution, our federal constitution. That will not change if this constitutional amendment passes. But there's more. As has been alluded to, those rights under the state constitution have been interpreted by our state courts to be more protective than your federal rights. Go to another state, you have less protection for religious liberty than you do in the state of Minnesota. That's not being touched. Our courts have interpreted to be a higher level of protection. Let's have that in mind. Now, that might say, well, we have these rights. Why not toss it in? We're wearing a belt. Why not put on suspenders? First, let's just point out, this is our foundational document, okay? I'm an attorney like many others. You're writing a contract, you don't kind of toss in a bunch of extra phrases just for the heck of it, right? Things have legal meaning. You want to be very careful what you toss in. Personally, I'm pretty thrilled with my right and yours that there shall be no control over interference with my rights of conscience. And I'm happy that that's true for you as well. That's not going to be touched. You start tossing other things in, I start getting concerned about exactly how that ends up working. We have our religious liberty. Now, I will say I don't see in this document references to the other portions in SF 37, to race, color, national origin, ancestry, et cetera, that we want to make sure are protected. Those are not currently protected. That's why Representative Hur is proposing that they be protected. Religious liberty is protected. That's why it's not in the amendment. But again, why not belt and suspenders? Well, I just want to make sure we're thinking about this clearly. Is it religious equality that we are looking for? Do we want to have the various faiths that Representative Nash outlined? Do they all get treated exactly the same, or is it religious liberty that we are looking for? Is it the freedom to practice our religion and to follow our conscience? The freedom to have, again, no interference with our rights of conscience. The freedom to worship God and to not worship God according to our dictates of our own conscience. That's what we're looking for. So I would just say, I think we want to be really careful about saying we're looking for equality of religion. I don't know that that's exactly what we're looking for. We want freedom, right? We want liberty, religious liberty. Section 16 of Article 1 is drafted carefully with a lot of detail to talk about the balance between our freedom of conscience and between, because of course we have generally applicable laws, and how do we balance those things out? Minnesota law comes out of our Constitution and has said, we're going to actually be pretty aggressive about protecting those freedom of conscience, much more than under the federal Constitution. Members, that has served us really, really well. We don't want to commit the category error of sticking an additional piece in this equal rights amendment. We're not looking for equal rights, we're looking for religious liberty. We're looking for the chance to have each of us practice our faith. I share the Christian faith of a number of folks who've spoken. I do. We have colleagues who share a number of the other faiths that Representative Nash stated. I think for many of us, that's why we're here. That's why we're doing this work at 1 in the morning, is because of our faith. That's true of many of us. And for many of us, it's not our faith, specifically in a divine being, that drives us to be here. It's other beliefs about the universe and our place within it. We all have that freedom of conscience. Members, that's what we're looking for, is that freedom of conscience. That's protected in our Article 1, Section 16. I think we want to be really, really careful about sticking additional words in our foundational document when we have a section that's working so very, very well. Let's provide equal rights in these categories that are not currently provided, and let's make sure then that we have our constitutional protections for religion, for our freedom of conscience, that are already in our Constitution. And boy, we do not want to make that mistake. So members, I would urge respectfully to my colleague, Representative Wolgamott, I would urge a no vote on this amendment. And let's be grateful for the freedom of conscience that we have. This amendment, this constitutional amendment is not going to threaten that. But it's possible that this amendment would. Vote it down. Thanks.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Wolgamott, for this amendment. And I appreciate the discussion that's happened so far. I especially appreciate, Representative Pinto, your ode to the care that we must take to writing new language in this foundational document. I look forward to your no vote on this underlying bill when we get to that point. I can't imagine you would vote for a bill for this kind of a radical change to our Constitution after less than 2 weeks from its first committee hearing. So I look forward to that conversation later. But Representative Wolgamott, thank you very much for at least trying to stand up for what's really one of the most fundamental American values, Minnesotan values, our freedom of conscience. It is right there in the preamble of the Minnesota Constitution. We, the people of the state of Minnesota, grateful to God for our civil and religious liberty and desiring to perpetuate its blessings and secure the same to ourselves and our posterity, do ordain and establish this Constitution. That is one of the fundamental purposes of our Constitution, is that we are grateful to God for our civil and religious liberties. And our Constitution, make no mistake about it, already maintains that all of us are equal. In Article 1, Section 2, it says, no member of this state shall be disenfranchised or deprived of any rights and privileges secured to any citizen thereof, unless by the law of the land or the judgment of his peers. And our state Supreme Court has interpreted that to be an equal protection clause, just like we also have an equal protection clause under the federal Constitution. And it is true that we have a First Amendment to the U.S. Constitution, and we do have some free exercise protections under the Minnesota Constitution. And current Minnesota case law, again, we've heard a lot of discussions about how current Minnesota case law might change in the future. Current Minnesota case law is very protective of free exercise. But Representative Wolgamott, you are absolutely correct that we need to take this additional step to make sure that we not only protect free exercise, but that we protect very clearly and very explicitly non-discrimination against religion. You're right, Representative Pinto, that those are two slightly different, though related, but slightly different categories. And we have one very clearly spelled out in the Minnesota Constitution. But if we pass this amendment without the Wolgamott Amendment, we won't be spelling out the other one. And Representative Wolgamott is absolutely right. That is especially important in this time of hostility towards many faiths. Violence against Catholics and Catholic churches, violence against our Jewish community, violence against our Muslim brothers and sisters in this state, violence against many different faith communities. And we need to be clear that when we're talking about creating and clarifying the compelling state interest that the state of Minnesota has in protecting Minnesotans against discrimination, that compelling state interest includes discrimination on the basis of religion. If we're going to list a bunch of other categories, we have to be very clear. There is discrimination, there is hate that happens on the basis of religion, and if we're going to call out the other categories, we have to be very clear that it covers this as well. Because if we don't, we leave the door open for, again, that future case law to develop in ways where judges might think that what we're saying is that it's not important. And I'm really concerned because I'm not hearing a good reason why not to do it. I'm not hearing a good reason why not to do it. And so Minnesotans are going to be left to wonder, why? Why is the majority voting against it if that's what happens here today? And judges who are going to interpret this down the road are going to have to understand, are going to have to ask that question as they try to interpret how these different constitutional provisions fit together. And it is going to erode religious liberty if we pass the underlying amendment without making clear that we are also saying that the state of Minnesota cannot discriminate on the basis of religion, has a compelling interest to protect discrimination even in effect on the basis of religion, alongside of all of the other things, including, for example, gender expression, right? We're talking about essentially speech in one area. The state of Minnesota is going to be told you can't discriminate, even in effect, on the basis of gender expression. But if we vote down the Wolgamott Amendment, we're not saying the same thing about faith. What are the courts supposed to make of that? And we've heard discussion about concern that some of these provisions in here are imposing a worldview, a controversial worldview on Minnesotans on a lot of these issues, including Minnesotans who don't agree, many because of their faith. We had a long discussion about what a state actor is under this. And there are concerns that the failure to clarify and tighten that definition of state actor means that some of these provisions are going to apply against faith institutions. In fact, the state of Minnesota is already arguing against two faith institutions that they are state actors. So if we don't make clear that non-discrimination principle also covers religion, what are courts to make of that? This, Representative Pinto, you're right about the current case law to an extent about what the Minnesota Supreme Court has said. And Minnesota has a proud tradition of supporting religious freedom. The U.S. Supreme Court, in a case that I disagree with called Employment Division versus Smith, it's one of a few Justice Scalia, one of his worst majority opinions, to be frank with you, said that the free exercise clause of the U.S. Constitution doesn't cover generally applicable laws that it might incidentally burden religion. And Minnesota had a case that was up from the Minnesota Supreme Court at that same time. It was sent back for reconsideration in light of that Employment Division versus Smith case. And in that case, Hirschberger, the Minnesota Supreme Court said, that's interesting, Justice Scalia, what you say about the First Amendment of the U.S. Constitution, but our Minnesota Constitution is stronger, and we have a proud tradition that we apply strict scrutiny. But strict scrutiny means you look at what is a compelling state interest and what's narrowly tailored. And we're now enshrining into our Minnesota Constitution additional compelling state interests that might infringe on someone's freedom of speech or freedom of religion. So it's important that we do clarify that we are not watering down free exercise rights, and in particular, that we are making clear that the equal protections, the freedom from discrimination protections that we're applying here, not just free exercise, but freedom from discrimination protections, which have different remedies, which have different tests, that also applies to all faiths as well. So thank you, Representative Wolgamott, for this amendment. I will certainly be supporting it. I hope that everyone in this room, everyone who stood up on their first day here and said that you were going to uphold the Constitution of the state of Minnesota, which is ordained and established for us, the people of Minnesota, grateful to God for our civil and religious liberties and for perpetuating its blessings to ourselves and our posterity. I hope we will make clear that the non-discrimination principles that already exist here, but if we're going to clarify them and make them longer and add more words to them, we certainly should clarify that covers people of faith as well. Please vote yes on the Wolgamott amendment.
The member from Crow Wing, Representative Davis.
Thank you, Madam Speaker. Representative Wolgamott, thank you for this amendment. And in a moment, I'd like to tell you why this amendment means so much to me. Truly thankful that you brought this forward because you sit in the majority. Representative Nash, I would also not only like to honor and thank Representative Wolgamott for this amendment, you had this amendment as well. Thank you for bringing this amendment, Representative Nash. It is very important, Representative Pinto, about being careful about what words we stick in our foundational document. That was my argument on the last amendment. I won't bring that up because I'll get ruled out of order. You kind of made my point for me. Again, I'll come back to what Minnesotans are going to read, and I hope to change your mind, Representative Pinto. I truly do. They're going to read, shall the Minnesota Constitution, I won't go through the whole thing, but shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, gender, and sexual orientation. That's what they're going to read. And what they're not going to read in that question is religion right now, as is, if this indeed does go to the voter. Why would we not submit one word just to be thorough and to make sure and put the importance in the question on the ballot of not discriminating against something? One little word, religion. And why does that word mean so much to me and so many others in this state? See, prior to me becoming a Christian, I was an atheist. And I hope I'll be allowed to tell my story because many have been allowed to tell their story, and it's a great honor for me to be able to tell my story over why this is so important to me and why I support it. Because I do hope to convince you that though I don't support the underlying bill, I absolutely support your amendment. And again, hope to light up this board green. That word religion you see before Christianity, I had a religion called atheism. And you might think that's not a religion. Oh, yes, it is. I could debate and argue that a few different ways. See, your religion is your worldview. It's what you view the world through. I viewed the world as through the eyes of an atheist who hated the name of Jesus, I had a hatred in my heart towards Christians and towards religious people. I really did, because I had great misunderstandings about religious people. Not all of them, but many of them. And you see, me as an atheist, I did have a God. Me. You see, I didn't want. The reason I was an atheist, and I found out this is why many are atheists, not all, perhaps, but I'm just saying for me and others. The reason why we had the religion of atheism was because we didn't want God telling us how to run our lives. I was the God of my world as an atheist. I was my God. So I had a religion. And my life absolutely spun out of control with me playing God in my life. I was an addict. I was full of hate. My wife at that time was ready to divorce me. And then at work one day, I got stuck working with the Christian. That's the way I tell that story. I got stuck working with the Christian. And he wasn't a perfect man, but he was the real deal. He lived out his faith before me. And I realized, man, there is something different about this guy, Representative Nash. I could tell by his walk with Jesus Christ, as you attested to. There was something different about this guy, and wow, what is it? And later on in that day, or over the next few days, I kept working with him and building a relationship with him. And then the weekend came, and we came back on a Monday, and he presented the gospel to me. He told me that Jesus had died for me. He told me that God had raised him from the dead on the third day. I remember this. He looked at me with love and compassion. He looked me right in the eyes and he said, "Ben, where are you going when you die?" And when he looked at me and he said that to me, I felt like God was staring right into my soul. Representative Wolgamott, I honestly do. I feel like God was staring right into my soul. And I looked at him and I said, I know where I'm going. I'm going to hell. No, that was just me. That was my testimony. I just knew it. And he looked at me with compassion and he said, it doesn't have to be that way. Jesus Christ paid a great price for you by dying on the sin as the Savior of this world. And a few hours later, as Representative Nash already testified to this, I surrendered my life to Christ. I said a prayer and I asked Jesus Christ to come into my life. And boy, did he. I found out Jesus is alive. And my life turned right side up real quick. Not overnight, and I'm still not a perfect man, far from it. Representative Wolgamott, I got a long ways to go. But boy, my life started to change. And I experienced the power of God through his son, Jesus Christ. That's why this amendment means so much to me. Because Jesus is alive and he absolutely changed my life. And I give him all the credit and glory for even being standing here before you right now. So I thank you for this amendment. And let's please, I thank you for this, yes, for this amendment. And I ask, please, members, that we would stick this one word in on the Wolgamott Amendment, on the Nash Amendment. Stick this one word in, please. Thank you.
The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Davis, that's a hard act to follow. But why is this important? Yes, our Constitution of the United States grants us freedom of religion, not from religion, of religion. And with that religion, it states, or with it in the bill, it states we can't discriminate like everything else because of that religion. We saw a lot of discrimination on religion the last few weeks at our college campuses across the country and at the University of Minnesota. Hatred towards those of our Jews and our Jewish faith. It was absolutely sickening watching what was going on. And then our university capitulates to those spreading that hate. Those individuals at that college campus have paid for and have a right to the education they paid for. But they were mostly locked out, afraid to go to the campus, to the school of this state of Minnesota, the university. Afraid in deep fear of harm. And the university did nothing. That's why this is important, to protect those kids. Protect each and every one of us against that discrimination that was shown so vividly at the university. Yes, freedom of religion is in our Constitution. But this amendment is about discrimination, not freedoms. This bill we're talking about is about discrimination. A few weeks ago, actually a month or so ago, maybe 2 months now, in the judiciary hearing, when we tried to put religion into the human rights bill, we were told it was intentionally left out. Shows where the priorities are.
Representative Johnson, I'm going to ask that you keep your remarks to the amendment and not go to motive. Representative Johnson.
Madam Speaker, it is. Because this is why it's important to be in there. We fought to get it in that bill. We did. And we're fighting for all religions now to get it in the bill so they cannot be discriminated against. Representative Wolgamott and Representative Nash, thank you for your amendments to put religion in. Please vote for this amendment.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker and members. So a year and a half ago, I attended a presentation on religious freedom. There was somebody in town from Texas who is sort of an expert on the issue of religious liberty. And it was an interesting presentation. I had some time to talk to this attorney afterwards, Stephen Collis. And it was interesting. We had a conversation about Minnesota specifically, and actually how Minnesota has traditionally been a reasonably good state when it comes to the freedom of religion. And in fact, he noted that during the pandemic, actually this was on a previous call with him, he noted that during the pandemic, Minnesota was actually good because we opened up our churches with other businesses that were allowed to open. And I thought, well, that's a little revisionist history. Because, of course, the governor's executive orders actually kept our churches closed until God bless the Catholic Church said, we are going to open. Whether you say we can or we can't, we are going to open. We will exercise our right to freedom of conscience. And God bless the Catholic Church, because they're actually the ones that got churches open during the pandemic. So a little revisionist history on that. But what that tells me is that our protection and religious freedom is not complete. And in fact, throughout this legislative biennium, we have seen a continual attack on religious liberty. Over and over and over again. So no, what is in the Constitution already is not sufficient, actually. And I went to Article 1, Section 16, and in fact, I think my note-taking was just ahead of Representative Niska's speaking, but I went through the entire amendment. The right to worship according to the dictates of our own conscience. We have the right to worship. We can't be compelled to worship. We can have no control or interference with our rights of conscience. No one gets to tell us what to do when it comes to our rights of conscience. No preference or establishment of religion. We're not going to have a state religion. We also can't use religion as an excuse for bad behavior. And no public monies going towards these things. In that list, there is no protection, there is no explicit protection against discrimination based on religion. And these things are treated differently. I subscribe to a faith that, frankly, I think in many circles it is one of the few faiths that it is still acceptable to mock. There's a whole Broadway play mocking my religion. It's celebrated. It's hilarious. So it does matter. I know that I've got my rights to conscience. I also want my right to not be discriminated against. And I think my Jewish friends and my Muslim friends want that same right. And my Protestant friends and my Catholic friends. Again, God bless the Catholic Church for standing up and demanding their rights. All of our rights. But make no mistake, what is in Article 1, Section 16 is not the same thing that we are putting in, where's this going? Section 18. It's not the same thing. It is absolutely not the same thing. Not only do I want freedom to worship according to the dictates of my own conscience, I want equal protection under the law based on my religion. I want freedom from discrimination. And I want it to be very clear that freedom from discrimination is equivalent to race, color, national origin, ancestry, disability, sex, including the decision to become or remain pregnant, gender, and sexual orientation. I want it to be clear that my religion is protected from discrimination along with all of those other things. In addition to my freedom to worship according to the dictates of my own conscience. And frankly, if the majority believes, which is what was said earlier, that, well, hey, this is no big deal, it's already in the Constitution, we don't need this, well then great, let's just throw it in here. That's a really easy solution. Because one of two things is true. Either this amendment is unnecessary and meaningless, or it is so meaningful that we're going to say, no, we don't want it. It can't be both ways. It cannot be both ways. It is either meaningless, in which case, great, add it in there. Because that will give a lot of people across this state a lot of comfort knowing that their religion and discrimination based on their religion is protected, just like all of these other things. That will give a great deal of people a lot of comfort knowing that. So if it doesn't matter, let's throw it in. But if you vote no on this amendment, that tells me that you think it does matter. That tells me that you think there is a difference. Because if there wasn't a difference, there's no reason to vote no. Literally none. There is no reason to vote no if you think that this explicit protection from discrimination is already there. There is no reason to vote no. So let's make sure that Minnesotans have a chance to look at the Equal Rights Amendment, and make no mistake, the Wolgamott Amendment will make it more equal than it currently is. If your belief is that the Wolgamott Amendment really doesn't matter, it's already there, then let's vote yes. And let's give Minnesotans some peace of mind. When they look at this amendment on the ballot, that they see this and they know, oh, hey, my religion, I will not be discriminated against based on my religion. Let's give Minnesotans that peace of mind. Let's make sure that they know that they will not be discriminated against based on their religion. Let's just vote yes. Let's just throw this in. Let's just throw this in. Thank you, Representative Wolgamott, for the amendment.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. Members and citizens watching, equal rights for all is different than equal rights for those on your list. When we do laws and make something legal or illegal, it's for everybody unless we list specifics. We call out specifics. And frankly, there's no reason why, if we all agree it should be protected, that it's not included. The idea that religions, beliefs are universally protected in our Constitution is not factual, because there's differences. Forcing a person to do something is different than preventing a person from doing something. If you force a person to do something that's against their religious beliefs, you shouldn't be able to do that. We used to have religious exemptions. However, those religious exemptions disappeared in too many cases in recent years. So again, equal rights for all means for all. But once you start delineating groups, then there's a different emphasis. And frankly, that's why we want to say, hey, we want to make sure that we include religion in this amendment. I have not heard one reason to exclude it other than it's already there. And frankly, I just gave the examples of why it should be included, because once you in law or anywhere make a list, you're specifying to that list. So once again, equal rights for all is different than equal rights for those on your list. Please include religion to our list of equal rights given.
The member from Douglas, Representative Franson. The member from Sherburne, Representative Lawrence.
Good morning, Madam Speaker. I think it's very fitting that we have a chance to discuss this topic on Sunday morning, 2 a.m., almost 2 a.m., according to what it looks like on the clock. And in a few hours, many of us would normally be home, be getting our kids out of bed maybe, or getting cleaned up and heading to church this very day. And so how appropriate that we get to talk about religion on this Sunday. Representative Pinto, I want to thank you for pulling out the Constitution, asking us to go through it with you and walking through an explanation there. I really do appreciate that. I've read through that numerous times. You taking me through it one more time was very beneficial, and I'm grateful for that. And we've heard over the last few days here that Representative Pinto, Representative Herr, that both you have referred to Section 16 here as being it's already covered. It's already covered. And so, members, if you're in question about how to vote on this, I ask that you just take a moment and reconsider. Because based on what we've talked about and the explanation that I've heard from Representative Pinto and reading through it over and over again, Section 16, I'm very grateful for. I'm grateful that it exists in our Minnesota State Constitution. It serves an extremely important purpose there, but it's not the same purpose. The purpose of Section 16 is that it gives every one of us the freedom to practice religion. It doesn't infringe on our freedom to practice religion. It says that we can't be denied our freedom to practice religion. It is a section that grants us the opportunity to practice. It ensures that opportunity to take action. Right? It's an action statement. We have that opportunity to practice religion as we've been called to do, in the faith that we've been granted. And so I see it as very, very differently from Section 16 to what we're talking about tonight. In the constitutional amendment that we're talking about, it states very clearly, the state shall not discriminate. Now that's a whole different game. That's a game changer. That the state cannot discriminate against, I talked about the list the other day, right? We're going to miss something out of the list. We talked about age. Today we're talking about religion a little bit. But the state shall not discriminate any person in the intent or effect on account of one or more of the following. Let's just put religion at the first one. The state shall not discriminate any one of us based on our religion. It's not granting me a purpose, but it's saying something completely different. And that's why it's so important that this morning, not tonight anymore, this morning, that we move to adopt the amendment that's before us. I don't remember the number. Amendment number 23. Amendment number 23, and put religion in here. Because there's two different things. And I just ask you, read the amendment again. I read it numerous times. I went through it over and over and tried to dissect it. And it wasn't until tonight that as going through with Representative Pinto, that it was like, hold on, I think I see something different here. Read the constitutional amendment. We're asking two different questions here. And the question tonight is to put Amendment 13 in here, vote yes on Amendment 13, add religion to the Section 18 here as one of the things that a person in the state of Minnesota cannot be discriminated against from the state. Thank you, Madam Speaker.
Closing argument, Representative Wolgamott.
Well, thank you, Madam Speaker. And before I get into my closing comments, I just wanted to double check that a roll call has been requested on this.
It has. Representative Wolgamott.
Okay, thank you, Madam Speaker. I recently saw a survey that showed that almost 80% of Minnesotans identify as religious. The A23 amendment is for them. It's also for the 20% of Minnesotans who don't identify as religious. This amendment is for those who worship with my family at Bethlehem Lutheran Church, who worship at the Islamic Center of St. Cloud, who worship at any of the number of religious places of the faith that Representative Nash shared with us earlier. Madam Speaker, this amendment is for those Minnesotans so that it can be the question on the ballot that the state shall not discriminate against them in intent or effect on account of their religion. That's who this amendment is for. Thank you, members, for the conversation. On behalf of faith-filled Minnesotans, I ask for your green vote.
The clerk will take the roll on the amendment.
Ash withdraws it.
Yep. Okay. And he's going to withdraw, but in a second. Will the clerk please call the names of the members voting remotely?
Acom.
Acom vote no.
Acom, no. Carroll.
Carroll, no.
Carroll, no.
The clerk will close the roll. There being 63 ayes and 67 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File Number 37.
Third reading, discussion to the bill. The member from Wright, Representative Hudson.
Thank you, Madam Speaker. Where to start? We've talked a lot about this underlying bill that would place a ballot question before voters in a couple of years to decide whether or not they want to fundamentally change the founding document of this state, the state constitution. And I was listening to the debate over the last amendment here, the Wolgamott amendment to place religion on the list. And I didn't realize we were on the last amendment. It's probably fortunate that I didn't rise to speak to it then, saved us some time. But I will make the point now that I was going to make then, which is I would have voted for that. I did vote for that. I supported it. But it didn't bring me any comfort. If it had been adopted, if we'd had the votes we needed to get religion put on the list of protected classes, it wouldn't have made me feel any better about the amendment itself. Because this amendment is a total train wreck. It is going to put the state constitution at war with itself. I mean, you look at the list. Don't have it in front of me right now, but the list of all these categories, off the top of my head, things like race, color, ancestry, national origin. I think that's actually the order that they're listed in. Now, if we were listing categories and the thing we were saying about them was all of these categories are going to be treated equally. That would be one thing, but that's not what the underlying language says. What it says, and we've discussed it quite a bit yesterday, is that they're protected from discrimination in intent or effect. And as we noted yesterday with the Niska Amendment, those two words, in effect, translate to any actual or perceived disparate impact based upon any of those categories. Now, I don't know how that works, and you don't know how that works. We know that you don't know how that works because questions have been asked of the author all through this debate, through all these amendments. What about this situation? What about that situation? And time again, the answer that we've gotten is, I can't speak to hypotheticals. Well, folks, the enterprise that we're undertaking here right now is amending our state constitution. We better think about the hypotheticals. And we better have some damn good answers as to how the change to the highest law of our state is going to impact any conceivable hypothetical. That's literally what legislating is. It's very reckless to put, just into statutory law, let's not even consider the Constitution, just in statutory law, to put in language that doesn't account for circumstance. Of course, we've seen that time and time again, the SRO issue. Safe storage law, both instances where we interpose ourselves between rational actors and the reasonableness standard, what a reasonable person would do in a given situation. Instead of relying upon that, because that language covers everything, we're going to interpose the specifics that don't take into account the many hypotheticals. And as a result, when we debated those things, long, lengthy, hours-long debate, because it raises so many questions. This amendment raises a lot of questions about how it's going to play out, and we haven't gotten any answers, literally none, as to how it's going to play out. We've gotten answers along the lines of, well, that's going to be affected in the way that the bill says it's going to be affected. I mean, that's almost verbatim, some of the answers we've gotten. That's not a good way to legislate, even in statutory law, but this is the Constitution of the state of Minnesota. So you're going to have all these categories that are at war with one another. In the discussion regarding the African American Family Preservation Act, as an example, the background on that, how we got to that point where we passed that out of this chamber and it is now going to be signed into law, the conversation within the community was not harmonious. The conversation in your caucus was not harmonious, I'm privileged to know. Why? Because as it turns out, diversity is just that. You can't just look at somebody's color and assume that they have the same values and that policy impacts them in the same way. And again, this is in the context of disparate impact. You guys are putting this into the Constitution. This idea of disparate impact means you're being discriminated against. In the context of the African American Family Preservation Act, you've got recent immigrants to the United States, you've got East Africans, you've got foundational Black Americans who can trace their ancestry back to those who were enslaved in this country. You've got folks, and the question becomes, okay, how do we balance that? Who gets to make a claim against who, and on what basis? How are we going to measure disparate impact today? Another complication on the African American Family Preservation Act that reared its ugly head in the Children and Families Committee was perceived potential conflict with our tribal nations, our tribal neighbors. And it ended up descending into this, and this isn't my description, oppression Olympics. Who's been more oppressed? Who's more entitled to claim that they've been, and it goes, there's two different sides of the transaction. Who's been more oppressed, number one, and then who's received more acknowledgement of that oppression. That's the formula, that's the dynamic, and that's the source of the fissures. And thank God we managed to navigate that, right? And get to the point where we were able to pass that bill off the floor. And we'll work through whatever complications may or may not rear their ugly head in the future. But what this amendment does, the state constitution, is it creates a constitutional mechanism for expanding exactly those types of conflicts, inflaming exactly those types of conflicts exponentially. And that's why the idea of just throwing religion onto the list didn't really give me, even though I voted for it, even though I supported the idea, didn't really give me a whole lot of comfort, because when you're sifting through a train wreck, the prospect of finding a car labeled religion doesn't really offer a whole lot of hope. I mean, I haven't even gotten to what the effect of this constitutional amendment is going to be. Right now, I'm just talking about good governance. This is terrible governance. This is a bad bill. Just as a bill. Just in terms of how it's drafted, the language, how it's going to, the impact that it's going to have on jurisprudence. But to make it worse, we're changing the state constitution to make it a bad constitution. That doesn't work. That can't be understood. That judges are going to be contending with. Well, which of these groups is primary in this instance? How do we measure disparate impact? From what perspective? Using which metric? We don't know. Nobody knows. How can you pass an amendment to a constitution that you can't define how it's going to function? Simple questions about what about this situation, what about that situation, can't get clear answers about how it's going to work. Just from a position of good governance, it's a bad bill and a terribly drafted amendment. But that's the least of it. That's the absolute least of it. As we've discussed thoroughly over the course of this debate, what this bill is going to do, what this amendment will do if ratified, is it's going to erase a whole lot of people from legal consideration, from legal acknowledgement. We've talked a lot about how it's going to erase women. It's going to erase them as a concept under the law by injecting this idea of gender expression and gender identity into the mix. And I don't know, we talked last night, got a little heated about the cruelty of merely saying that a woman is an adult human female. That just factual statement makes people cringe for some reason. But love it or hate it, it's an objective statement. You can do things with that. You can adjudicate with that objective definition of what a woman is. Gender identity, gender expression, that's the interesting thing is you go down those categories, color, race, ancestry, national origin. There's some subjectivity in there with some of them, but largely, those are things that you can quantify, you can observe, they're innate characteristics, you're born with them. And don't tell me you're born with a gender identity, because one of the concepts that's part of gender theory is gender fluidity, meaning you can just change it whenever you want. You can go from this to that and then back again. So what you're doing is you're inserting into the law a category for discrimination claims based upon disparate impact in effect and the underlying category itself has no actual definition. It's literally whatever's in your head right now. Just going back to the concept of good governance, how are you going to quantify that? How are you going to track it? What government agency or department is going to have the capacity to come up with reliable statistics about how such and such policy and such state entity is having a disparate impact upon, I don't know, look me up a name of one of these random gender identities that we're apparently supposed to be acknowledging. That'd be a good question. I won't ask it because I don't want to know the answer. How many of them are there? I'm guessing the list is above 3 figures. So how are you going to quantify it? How do you know? Somebody makes a claim, maybe they're lying. You're going to take it on faith? That's not how government should work. You should be able to adjudicate, you should be able to find facts. If you can't make a finding of fact as it relates to the implementation of law, then it's a pretty bad law. And because that's what you're doing, the impact is going to be by putting in a category that has no objective definition and that can shift with the wind on its own terms. On its own terms, it can shift with the wind. What you're doing is you're subordinating every other category to that. Because I can't change my race. I can't change my color. I can't change my ancestry or my national origin. I can't claim to be something other than what I am in each of those categories. But whoa, here we come. Gender identity. I can pick one. Which one's going to be most politically advantageous to me today? Which one's going to entitle me to reparation for disparate impact that I can allege? You're going to create an incentive in the state constitution for people to claim, whether they actually believe it or not, that they align with certain categories so that they can benefit from wherever the political winds are shifting at that particular moment. And of course, there's the well-worn topic that we've discussed quite a bit of how this imposes upon freedom of conscience. Chair Pinto, I swear, I heard you say it twice. We're not looking for equal rights. Now, I'm going to grant you a very generous interpretation of that comment. But it was fascinating. I could not follow your argument. I legitimately couldn't. Article 1, Section 16 of the Constitution protects freedom of conscience. So that's where our freedom of worship is, religious liberty. But this is something different, is kind of what I was discerning. Like that this is a different category because it's dealing with discrimination. I'll just go ahead and will Chair Pinto yield to a question.
He will yield. Representative Hudson.
Thank you, Madam Speaker. Chair Pinto, could you please expound upon the case you made earlier in relation to the Wolgamott Amendment regarding the distinction between Article 1, Section 16 and the language in this bill?
Representative Pinto.
Thank you, Madam Speaker, and thanks, Representative Hudson. Yeah, so Representative Hudson, the idea is that, and I actually think maybe it can be seen clearly if you just look at the language in the amendment. It says the state shall not discriminate against any person on account of one or more of the following. And I'll note, by the way, if religion had been added, people were talking about how it'd be discriminated against based on your religion, but it doesn't actually say that. So the concern is state shall not discriminate on account of religion. Well, that would say kind of anybody's religion, right? Can't discriminate against somebody because, like the idea is we're saying, look, we don't want to treat every single person of any religion in an equal way, in the same way. The idea is, I think the folks advancing this, is to say, what we want is the opportunity to make our own decisions about, let's say, gender identity or gender expression or these other things, about how to treat people and how to sort of be in the world. That's the point of freedom of religion. And so you're not looking for equality to have somebody of every single one of those religious backgrounds being treated exactly the same. The idea is that there is the freedom of conscience and the freedom of religion to worship in the way that you want, believe the way that you want, including a way that may be different than other people in society, and it may be the same as other people in society. So that's where it's different than these other categories that are listed here. In balancing out religious liberty and equality of religion, I don't think that it's that equality that's being sought, it's that religious liberty that's being sought.
Representative Hudson.
Thank you, Madam Speaker. Thank you, Chair Pinto. Would Chair Pinto yield to another question?
He will yield. Representative Hudson.
Thank you, Madam Speaker. Chair Pinto, could you clarify for me what your concern, how your concern would play out if religion had been added to this list and was therefore one of these categories where we cannot discriminate in effect? What would the harm of that be, potentially, of having religion in there as a category?
Representative Pinto.
Thank you, Madam Speaker. And Representative Hudson, I want to be careful not to violate the rules about, because of course we're beyond the amendment. So I'm going to go, but if at some point I may get cut off on that. So the idea would be to say, you might say, listen, because of my Christian faith, somebody else might say this, because of their Christian faith, they may disagree with something about gender identities, sex, whatever it is, right? And I think that that's a lot of what was motivating that. Well, the thought is, wait a second, why do they get an exception because of their religion? Because we can't have any kind of discrimination, any difference based on religion. And notice that it doesn't say based on your religion, right? It just says based on religion. Now, is that something that I would say is a guaranteed concern? I would say it's guaranteed, but it is certainly a significant risk. And when we say we've already got Article 1, Section 16, I get real worried about adding language that could potentially undermine that point. So that would at least be one example of a concern that could have been raised in adding that term. And again, I'll just note, it would have said the state shall not discriminate on account of religion, against any person on account of religion. You cannot discriminate against an atheist on account of religion, on account of somebody else's religion. So it's not necessarily your religion. As I say, we've moved on from the amendment, but I did want to make sure to answer your question. Thank you, Madam Speaker.
Representative Hudson.
Thank you, Madam Speaker, and I do appreciate the latitude, although I would argue that we are arguing to the underlying bill simply because the concept that I'm trying to flesh out is what is the logic that applies to including something like religion into this list that could also be applied to other items that are on the list. You're correct, it doesn't say your religion in the Wolgamott Amendment. It doesn't say your gender identity in this underlying bill. And just like religions, there's a spectrum of religions, and there's even denominations within religions, varieties of different potentially conflicting beliefs. There's apparently an entire spectrum of gender identities. Is that going to create some problems, you think, maybe? Again, unquantifiable. Potentially vying one against the other for who within that community, like the different, again, diversity within communities, right? Which subsection of the subsection is getting a rawer deal than the one next to them? That's what you're setting up with this. But, I want to get to, and then I'll pass it off to the next person who wants to talk about this, the part that really gets me. And I've already alluded to it. We have a history in this country, starting from its founding, of trying to meet a promise that was well articulated in the Declaration of Independence, but was not at first perfectly met and has never been perfectly met. The idea that all men are created equal. And in the context of the time, men meant mankind, everyone, that everyone is created equal. And of course, people were not treated equally in the beginning at this nation's founding. But we've gotten better. We've gotten a lot better. And as time has progressed, the further along the timeline we've gone, the rate at which we've gotten better has increased. I mean, you think about the difference between 1864 and 1964, pretty significant improvements in quality of life and the way that people were treated, and equality across the board. Obviously not perfect. A lot of things needed to happen in 1964. But what was it? Now I'm trying to do math at 2 in the morning. 14 years later, I was born. 14 years after the passage of the Civil Rights Act. I got to grow up because of that work, because of that looking ahead to posterity, and because of the work to make things better, to raise people up, to grant them rights. I got to enjoy a childhood where I didn't have to worry about what my dad had to worry about. And I couldn't even conceive of what my grandfather had to worry about. And I remember growing up and hearing stories about Jim Crow, reading in history books about chattel slavery, seeing depictions on the silver screen of Nazi Germany in World War II, the Holocaust, the horrors that people are capable of inflicting upon other people. And there was always a detachment from all of it, and a gratitude that came with that detachment of, I can't even contemplate a world where that is possible. I can't even contemplate a people who would be willing to do such things to other people. And naively, in my youth, thinking that's the way it's always going to be. We're always going to be moving forward. We're always going to be progressing. It's always going to be getting better. Then last year, we passed into statutory law language which strips the civil rights from an entire category of human beings based upon an innate quality that they have no control over, being unborn. That's not a protected class, for damn sure. Unborn. And it's interesting, we talk about disparate impact. You guys are going to have to figure this one out. Yeah, I don't think you've thought this one through. What happens when somebody figures out the disparate impact that one of your rights enshrined in here, the ability to kill your unborn child up until the moment it draws its first breath of fresh air, conflicts with another category? Which group of people do you think are the most disproportionately represented in those slain by the industry of abortion? Well, to borrow a phrase from Representative Frazier, it's those who look like me. It's amazing how the concern for disparate impact has a cutoff at the most vulnerable, the most helpless. Suddenly we don't care anymore. And now, Now what we're going to do is we're going to change the Constitution of the state of Minnesota so that for perpetuity, for all time, until such time as the state becomes better, gets better, we're going to calcify the permanent stripping of civil rights from the unborn. This vote here, I mean, it's been a rough term. I'm not going to lie. I've seen a lot of darkness in this chamber. But this here, this is, I have to imagine, the most consequential vote that I will ever take. The decision whether or not to put into the highest law of our land a repeal of civil rights for human beings. And it's interesting, because I did bring that up earlier when we were debating one of the amendments. And I saw some looks of confusion, some shaking of heads, like you either didn't know what I was talking about or disagreed with it. I think it might have been the second. I don't know, can't say for sure, can't impugn motives. But either way, are we not dealing with human beings? Is that what we're saying here? I think it's worth contemplating before we cast this vote. Again, just the gravity of it. The gravity of applying pressure to the button and having the board light up next to your name and recorded in the journal of this House for posterity, declaring that Representative Engen's son, if still in the womb, simply does not matter. That any baby at any stage of gestational development simply does not matter. It's a hell of a thing. I hope you're really deeply contemplating what you're about to do, what the impact of it is going to be. I never thought I would be in one of those stories that I was told as a child, at a moment where the unpopular thing to do was affirm humanity. I mean, that's what you're banking on, right? I mean, and again, that's not impugning motives because this is a ballot question. So the implication is that you believe that the majority of Minnesotans are with you. And if that's true, then what I'm saying is true. The unpopular thing to do right now, in this moment, is to affirm the humanity of the unborn. I'm comfortable with that. I just never thought I'd have to do it. I've said on this floor before, I'm comfortable being the only person standing against everyone if I'm right. I just never thought I would have to do it. Thank you, Madam Speaker.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. And first of all, I listen closely to what words the author uses because legislative intent matters. And on this bill, there are some concerns with that. And I think we've hit that before. I just want you to realize that when you vote. Next, as to the previous decision or discussion about the XXY and other variations, genetic variations, I thought for decades that was common knowledge because of the Olympics when they determined a team from One Nation had, according to their defined rules, biological men on the team. And that was defined by having a Y chromosome, even if they had 2 X chromosomes. And that was the policy of where they stopped letting men, biological men, compete on women's teams. We had amendments to try and protect women's teams, but of course, they didn't get the votes. And I think that's unfair to the girls and women, because frankly, with an unknown number of genders, maybe you need 3, 4, 5, 6, a dozen different teams, or what it ends up doing is you'll have one team. If there really is no difference genetically to capabilities, then you would have one basketball team, one soccer team, one hockey team, one track team, etc. But if you look at the collegiate and world records, you notice there's is a difference. And we've talked about it. And frankly, I have enjoyed what Title IX has given to our community. And the way that you've got this bill and the amendment, you would get rid of Title IX. It'd be gone. There was an amendment, it got pulled. For many terms, I've had a bill that said in a school where students are in a situation where there's reasonable expectation of partial or complete undress, that it would be separated by biological gender. That bill, there's a student or youth legislative event that goes on. I've had several bills that they've asked to be, part of their program. One was the bill that stated this. And it was a good discussion, and the vote was very close, but the vote was against the bill. After that, one of the youth came up and said, "Thank you. Thank you for this bill. I voted against it because of peer pressure. I hope you get it passed." And then another student came up. And another, and another, and another. So, the majority of them either voted for it or came up and told me, "I wish I could have voted for it, but the peer pressure, and we need that." Because teenage years and adolescence are tough. And it's not fair. It comes down to this. You've got a student that you're concerned about not feeling included, and you're going to have them utilize the girls' locker room. What if a girl is uncomfortable with that? I was told, well, she would need to get over it. What if it's 2 or 3 or 4 or 5 girls that would feel uncomfortable with that? We had more than that speaking on the floor, women, many of them mothers, who tried to explain that is not a situation that you should put girls in. Or in situations where they've had a traumatic experience and they go somewhere to feel safe and there's a concern. Frankly, the equal rights of those girls should matter. And we had amendments that would have taken that into consideration, all shot down. You even had one of your members bring an amendment on religious freedom, and that was shot down. I hope the people watching understand the reality of this bill, and I'm voting no because it's not ready, it's not right. It should not be combining an omnibus amendment to our Constitution. It should always be single issue. Each thing should pass by merit alone, not because you stuffed it in with something that's popular. That's not how you do a good Constitution. Vote no.
The member from Ramsey, Representative Finke.
Thank you, Madam Speaker. Members, good evening. It's almost 2:45 on, I think, day 3 or 4 of the debate for the Equal Rights Amendment, as I have been calling it the Inclusive Equal Rights Amendment. And I'm not going to make another long speech, but I did want to just make sure we took a second and celebrated what we are doing here. We are doing something tremendously exciting when we pass this Equal Rights Amendment. We heard a couple of times about how this is not your mom or your grandmom's ERA, but this is my mom's ERA. She's really excited about it. It has the old original ERA. It's the ERA plus. It's okay to change things, to move forward, to recognize that time changes, people changes, culture changes, protections change as well. We have a 100-year civil rights movement moving forward. It's the queer civil rights movement. And every time we take a step forward, we hear the same arguments about the destruction of culture. And the destruction of culture never comes because it's not real. They're just people being recognized for who they are, living their fullest authentic lives. It's a great moment to celebrate. I'm really grateful to the advocates for the ERA who have been so welcoming to the trans community in this fight. They know who they are. They've been doing this work for decades. I'm really grateful to the women on all sides of the aisle who have fought to get here, especially the queer suffragists and the trans suffragists who were spending their time with Susan B. Anthony and who were marching in the 20s and who were doing this work all alongside their cisgender women, trans women, queer women, lesbians, the whole gang. We've always been there. The rooms have always been super gay, y'all. Alice Paul was gay. There are queer people everywhere throughout this history. There is this idea that there is women who are pro the rights of women and everyone on our side who is like anti-woman. It's just so absurd. We need to stop falling into these simple binaries that just pretend like the women who support trans women's rights are somehow not pro the ERA. It's so silly. So we're going to make a trans-inclusive ERA. We're going to hopefully put it in the Constitution. We are not voting for that tonight. I think that's a good reminder. But what we are doing is taking a step forward, continuing to lead in the state of Minnesota for the protection of all people. And the all people here does mean all. It means trans women and girls, which we have talked at length. At length. I never want to talk about trans women again. But it also means trans men, who we continually erase from this conversation. Nobody ever took up the difficult piece of trans men in sports because it doesn't make sense. If you try to deal with trans men playing on the girls' teams, it doesn't work. We're also protecting non-binary people, two-spirit people, and genderqueer people. And I think that's wonderfully exciting. We should put everyone's protection in the Constitution, not because of superiority, but because of equality. Equal rights means equal for all. We've heard that, and it's time to recognize that equal means equal for all. So thank you so much to everyone who is going to vote for this tonight. I'm very tired, and please vote for the ERA.
The member from Sherburne, Representative Lawrence. No. I wasn't sure if you stood up. Maybe you didn't.
I didn't, but I can speak, Madam Speaker. Madam Speaker, you called on
really,
me.
We're good. If I was mistaken, I'm not imploring you to
No,
speak.
I know,
Representative Lawrence.
but I should say a couple words as we're coming to the board here. I'm getting the.
Did you want to talk to Representative Davids about what first termers?
I thank you for recognizing me and thinking about it. Have a good night. Good morning.
The member from Scott, Representative Bakeberg.
Well, hopefully I don't get cheered down as well. I think one of the things I love about our country is that people can choose to live their best life and how they choose to live their life as an adult. And I think that's really part of the big conversation. And my perspective is we had a lot of conversations today, and we were focused on kids. And there were a number of amendments, and Representative Finke talked about different groups. And that's really when we started this conversation yesterday morning, I believe it was, and about the amendment to include all. Because truly, all means all. We truly believe that equal rights must be for all people. I believe that. Equal rights must be for all people. I heard an analogy where when a tsunami happens, the water is pulled back and it exposes the ground. And it exposes the beautiful things, and it exposes some hard things as well. And I think from a different perspective on this, what happens is sometimes when a tsunami happens, people rush out not knowing what is going to come and what is going to happen. And then there are people that are standing there saying, no, 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 don't go, because they know what is going to happen. When I talked yesterday, I talked about that concept of who's my neighbor. And it really goes back to that all means all. Equal rights are for all of us. And what I see in this is that there are unequal rights in this proposal. We've talked extensively about abortion up until the moment of birth. And after that was passed out of this body, I've had extensive conversations with constituents, many of them pro-choice constituents, saying, well, I didn't know that's what it was. So That's the first thing. It enshrines in our Constitution abortion up until the moment of birth. And we heard about Representative Engen's son. We offered an amendment to exclude age, to be able to protect our elderly. And I talked about my 97-year-old grandmother. She is not in this. We've heard on this floor, and I'm going to read this so I get this right. Trans women are women. Trans girls are girls. First off, we are all human beings. Representative Davis talked about, from his worldview, from a biblical worldview, how he believes God creates people. And what happens, and my concern, is that when we elevate, and that's my perspective, my words, but when we elevate trans women in this equal rights amendment proposal, it is going to eliminate safe spaces for my daughter, my granddaughter. My future granddaughters, hopefully, Lord willing, someday, may not have athletic teams with same-sex teammates and people that they compete against. We just saw a vote, and frankly, in my opinion, continuing an attack on religious liberty. And my probably another concern is that we got nearly 50 years of amazing work of women that my wife, my daughter, my future granddaughter, my future daughters-in-law are going to lose. And I know many of you across the aisle see that differently. Obviously. But from my perspective, this ERA is an unequal rights amendment, and it does not provide protections and equal rights for all.
The member from Mauer, Representative Mueller.
Thank you, Madam Speaker. And members, I'm going to do something that I rarely do, which is read some of the things that I've written down. Normally, I'm very good at just talking what's in my heart. But this is a difficult issue for me. And so I wanted to write it down to make sure that I was able to speak it in a way that was clear and that was compassionate. I cannot vote for this ERA for 3 reasons. The first is I believe it's deceptive because the language that's on the ballot is different and has different meaning than what is actually in the bill, and we've already talked about what that is. I believe it's divisive, that it takes an amendment and a philosophy that we all agree about, equality for all, and that we actually appropriate it and take it into something that is different, puts extreme ideology in it, like abortion up to birth. 64% of Minnesotans believe that the question of equal rights and unlimited abortion up to birth should be separate questions. So I can't support it because I believe taking a concept and a belief that all of us share and adding divisive language does not bring equality to all. The third reason, and this is the one I'm going to probably focus the most on. To me, as a woman standing in this Capitol, standing in the Minnesota House of Representatives with a doctorate, who has been married for almost 20 years, who has been voted and elected by her constituents twice. I cannot imagine this amendment, whether it's the 1970s or the 2024 amendment, being more demoralizing. And I bet you're wondering why that is, considering you're like, why wouldn't you want to be equal? One of my favorite shows is The West Wing. And I watched it hundreds of times. And in that show, they have a character named Ainsley Hayes. And Ainsley Hayes is the token conservative character that shares the views of the conservative people, whatever that even means, because not everyone thinks the same. And someone was talking to her about the ERA, and she said something like this: "It's humiliating. A new amendment that we vote on declaring that I am equal under the law to a man. I am mortified to discover there is reason to believe I wasn't before. I do not have to have my rights handed down to me by a bunch of old white men, or in this case, from other people across the aisle. The same Article 14 that protects you protects me." And she says something else, but I'm going to say, and I read the Constitution just to find out. This country has worked really hard to ensure equal rights, including the 14th and 19th Amendment. Women have fought for the rights I enjoy today and that I hope my nieces enjoy in the future. Nothing holds them back. I can't think of a law right now, a law that says that I can't do something, that is written into law that I cannot do it. I can vote, I can get a job, I can marry, I can get divorced, I can get paid, I can become anything I want. I grew up in the 80s when they were pushing STEM for women. Man, women are in every vocation in this country, every vocation. They're everywhere. We are not limited by the law. I can't vote for this, and not because I don't believe women shouldn't be equal, but because I believe they already are. I appreciate the debate that was happening about these amendments, because it honestly revealed to me just how annoying to me this is. Every exception that we tried to talk about in the amendments, people said, hey, look, it's already covered under the Constitution. Great, we don't need this. When you start delineating out protected classes, you open up Pandora's box because you start thinking about, oh, who else are we supposed to be putting in there? When you put in that no member of this state shall be disenfranchised or deprived under the rights or privileges secured to any citizen thereof, when you start saying that all men and women are created equal, full stop. And we have worked hard in this country to make sure that the laws do not discriminate and that the laws do not hold women back One of the best things that I think about this country is that we have a spirit of individualism, that each person has an intrinsic value with their own unique gifts, talents, and beliefs. No one person thinks the same as anyone else completely. And when we start getting these tribal mentalities, like it so often do in politics, we're going to start believing things that are different. Humans thrive in an environment of freedom, and this amendment, when it starts delineating out protected classes, is not freedom. It says, I heard from the other side of the aisle, we need to put everyone's protection in the Constitution. It's there. It's already there. One of the first times that I spoke on this floor during COVID was to decide about whether or not to remove emergency powers. And I remember walking to the chamber very empty because no one was here. And I had enough time to look at the quotes on the wall. And one of the quotes says that votes should be weighted, not just counted. Our votes cannot be just counted, they must be weighted. The weight of this vote is heavy for me. The weight of this vote is heavy for me. To think that we need to somehow show that apparently people don't see me as an equal because of me being a female. It's heavy. To think that my nieces, that my sister, that my mom would not be considered equal is heavy on me. We have worked hard to abolish discrimination in our laws. We now need to abolish it in our hearts. This amendment doesn't do that. I ask that you vote no.
The member from Anoka, Representative Scott.
Thanks, Madam Speaker. Members, I know it's getting late and we're all super tired. So thanks for walking through this with us. You know, I'm sitting here and I'm looking back to last year and the amount of time and effort that was spent on repealing every single abortion related law that was on Minnesota books, from parental right to know, a woman's right to know, even the data keeping. Even the data keeping was stripped out. And the most egregious thing that was repealed was the Infant Born Alive Protection Act. And basically, abortion in the state of Minnesota is allowable up to birth now. We've talked about how that's comparable to China and North Korea. Not a good look. And most people are learning that slowly in the state of Minnesota, and they're not okay with it. But what I don't understand is, given all that was done last year, why didn't you just have a ballot question that says, shall Minnesota enshrine abortion up till birth into our Constitution? That's what you want. Ask for it. Why are you all of a sudden backing away from that or trying to blur what you really want by adding these other things in? And I understand, you know, there is a demand from your caucus to put these other protections in there, but it's disingenuous in my mind to have, again, this kind of fruit basket amendment that's going to go on the ballot in 2026. And, you know, I made a little chart here. It's just a little triangle. And I know we're not supposed to necessarily use props, so I'll just put it back down. But we've talked a lot about unequal rights. So what I have at the top, it's a triangle, kind of like Maslow's hierarchy, right? So tier 1 rights, and we've got all the things that you have listed that are protected from discrimination in your constitutional amendment. And then below that's the tier 2 rights. And that's all the people who are being canceled out by the tier 1 rights, which are biological women, biological girls, people with religious faith. Age is eliminated, and all other humans. And then down at the very bottom, outside of the triangle altogether, are preborn children, because they have 0 rights here, 0. That is what you want to put in the Constitution? Think about that. What kind of a state do we want to be known as? Thank you, Representative Mueller. I know she's off the floor now. But thank you for articulating what you did. You know, of just saying that we already all have rights, equal rights under the law. Now we're going to have some with tier 1, others with tier 2 rights, and some with 0 rights. Members, this is not good for the people of Minnesota. Please, please vote no.
The member from Todd, Representative Wiener.
Thank you, Madam Chair and members. Been a lot of testimony, a lot of good input on this bill. A lot of things to consider. Although I had a pretty good idea how I was going to vote for this a long time ago. Over the weekend, my daughter fell off the monkey bars, broke her arm. So I was in the hospital for about 2 days, and I took the time to ask people questions. What are your thoughts on this bill? And I read that to them, people I didn't know. And there was a reoccurring theme. It seems kind of vague, ambiguous. And that's really bothered me. If we're going to write pieces of legislation and make them vague and ambiguous, why would we do that? Go back to the Greeks and Romans, and I don't remember who said it, but let your answers be CC, no, no. Yes, yes, no, no. Simple. But why would we do this on this bill? Why would we change our Constitution? How many times have we changed it? Another question I asked myself. 213 times since we became a state. 213 times it's been looked at. 120 times it's been approved. So I go through and I look at almost all of them. I didn't read all of them, but pretty close. And what I found a reoccurring theme was every one of those constitutional amendments are very clear. They're very plain. A simple person can read it and understand what it means. So why make this constitutional amendment ambiguous? And something that was discussed tonight, and thank you, Chair Pinto, I listened to what you have to say. I think you have a very legal mind, and I appreciate your words. You said something about the religious amendment. You said that it should have a lot of detail, and yet here this bill has ambiguous nature to it. So a little bit more research. Cornell law. Why do constitutions and statutes sometimes have ambiguous language? because legislators may intend different things than what they vote for. And that's exactly the way this is written. That's exactly why there's a problem with this. And that's exactly why I was a no from the very beginning. But this is more to the people out here in Greater Minnesota. If your laws are unclear, if your laws are not simple enough to understand, if a constitutional amendment makes you wonder what the heck it even says, you're being lied to. You're being deceived. There is another intention. How do you feel when the people here that are supposed to represent you are trying to deceive you? How do you feel about that? Because this is going to be enshrined in our Constitution if this passes. You're going to get to vote on it. How do you feel? We can do better. We are not serving the great people of this state by writing a constitutional amendment that is vague, ambiguous, and meant to deceive. Vote no on this bill.
The member from Hennepin, Representative Bonner.
Thank you, Madam Chair, and thank you, members. It's been a long night. Actually, a long couple of days, a long couple of decades. But I want to say thank you for the discussion this evening. It's been robust. We found areas where we agree and some where we differ. But I want to thank all the warriors in this work. To Representative Herr, who's done all this, Representative Finke, Representative Hornstein, who carried this bill, and those in the galleries and online who've been here day after day, year after year, and many decade after decade, including some still up in the gallery at this late hour. And I want to thank the giants of Gloria Steinem, who is, by the way, following this debate tonight, and the spirit of Corinne Korbel, and my mentor, who grounds me, Rosemary Rocco. The proposal that we've discussed at length today amends the Constitution and very clearly states, out loud and in plain English, that we value lifting up all people. In the state of Minnesota, at the highest level of legal scrutiny, which should ensure equality, freedom, and autonomy in all its forms. I want to thank those of you who shared your appreciation for the 1973 passage of the federal ERA. And I appreciate the acknowledgement of the hard work that went into achieving this for over 100 years. We've heard for generations the fear around this issue and what it means to a changing society. In the days of Phyllis Schlafly, it was about the idea of women serving in the military or women becoming pastors in the church. Today, women serve with honor and distinction side by side with their male comrades. Today, women pastors flourish and continue to watch our flocks and our faith communities. Sadly, when we talk to constitutional scholars, the 14th and the 19th Amendment the 14th Amendment, does not provide the protections we think it does. And sadly, there are laws that we rely on today that don't protect us in the eyes of the law. Anton Scalia, our Supreme Court Justice, once said that while the Constitution does not encourage discrimination, it also doesn't forbid it. And that speaks volumes. We've come a long way and yet not far enough. We've created an elaborate set of laws to protect against discrimination, but without the highest level of legal scrutiny. It is a literal roll of the dice on whether or not our laws will be enforced. Ruth Bader Ginsburg once referenced Sarah Grimke when she said, "I ask no favor for my sex. All I ask is for our brethren to take their feet off our necks." And I can tell you, members, that I am not comfortable not being a protected class under our state constitution. I am not comfortable gambling on whether my rights are protected at the highest level, at the highest laws of the laws of our state. I am grateful that the Minnesota courts have interpreted our religious liberty and are to be superior to the protections in the federal constitution and those of the states around us. It gives me great comfort. Lifting up protections from discrimination up to the same highest level of level standards ensures that the hard-fought and won rights and freedoms we enjoy cannot be washed away in a world that is often uncertain. That is the promise of our Constitution, to withstand the test of time. But now is a time to be grateful. It is a time when indeed we stand on the shoulders of giants who came before us, who endured discrimination, disrespect, and disregard, whose voices were silenced, some more than others, fighting for equality, freedom, and autonomy over their own bodies, which began all the way back with our sisters, the abolitionists. Women who planted trees in whose shade they knew they may well never enjoy, but they persisted nonetheless. Over generations, we have grown strong. We have grown taller and more comfortable in our own skin, more powerful in our own inner strength. Throughout history, white, black, brown, and indigenous women stood shoulder to shoulder for generations because they understood that their fates were linked. They understood that where discrimination flourishes, it impacts us all. That sexism, racism, discrimination based on who you are inside and out, based on who you love, or discrimination that overrides the right to control over our own bodies, our own bodily freedom, that all forms of discrimination are not ranked, they're linked. This is why we grew strong in the knowledge that we must lift up all people. For if one of us is not equal under the law, none of us are truly free. It is time, members, to walk boldly towards freedom. It is time to walk boldly towards equality. It is time to walk boldly toward autonomy over our own bodies. And most importantly, it is time to declare Minnesota a discrimination-free zone. Please join me in voting green.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. We've covered a lot of ground, frankly, not enough ground for a topic of this kind of gravity. But I've been, like Representative Mueller, feeling a great weight around this issue because we do all believe, I think, in equality. The Declaration of Independence, the promise that Representative Hudson was referring to, is the closest thing we have to an American creed, that we're all created equal. Endowed by our Creator with certain unalienable rights like life, liberty, and the pursuit of happiness, and the purpose of government is to secure those rights. I hope we all believe in that. I think a lot of Minnesotans believe in that. But I'm very concerned as I study this amendment and I think about its implications and ask questions about its implications. I'm very concerned that Minnesotans are being sold potentially a bill of goods, a deceptive trade practice, so to speak. There are many reasons this amendment is a bad idea. But the most important, I think, is that it deceives Minnesotans to think that it's for equal rights, and it's really an unequal rights amendment. There are many reasons, and we've covered a lot of ground tonight, but I do want to try to summarize the most important of them, starting with the fact that it's unnecessary. At least if it's really just about equality, it's unnecessary. The Minnesota Constitution already has within it equal protection, and the Minnesota Supreme Court has applied that. You know, Minnesota Supreme Court has struck down actually distinct laws that we had in the past that distinguished between crack cocaine and powder cocaine on the grounds of our equal protection clause. Minnesota has equal protection already embedded in its state constitution. We have a Minnesota Human Rights Act that comprehensively protects against discrimination. And if this amendment's about abortion, Minnesota already has the most extreme abortion policy in the country. But that's not what this unequal rights amendment really does. It reduces rights. It erodes women's rights. It erases sex distinctions. As we discussed in previous debates, that's essentially the point. We attempted to clarify that with some amendments, and those were shot down. It's also an unequal rights amendment that attacks and erodes religious liberty and free speech. As we've discussed, it imposes a controversial worldview on Minnesotans, many of whom don't believe it. We failed to clarify what a state actor is, meaning that this amendment might impose on private organizations and private actors. And it doesn't protect against religious discrimination. We had an opportunity to do so, and it was rejected. And I think Minnesotans are right to ask why. Why? Why wouldn't this amendment, if it's an amendment to prevent discrimination, why wouldn't it say anti-Semitism is out of bounds? Why wouldn't it say Islamophobia is out of bounds? Why wouldn't it say that discrimination against the Mormon church is out of bounds, or the Christian church? Why wouldn't it? I think a lot of people rightly are concerned that there's a different agenda behind this. That's not just about equality or anti-discrimination. This amendment was partisan. It's deceptive, and it's been rushed through the process. It writes partisan politics into our Constitution. That was made clear from the conversation we had earlier on in the debate. Some individual groups were more marginalized. Those are the ones that got singled out, chosen by one party. And we're rushing through a constitutional amendment now, at the end of this legislative session in 2024, for a vote. This is such an important issue, we're going to put off the vote for 2.5 years until the 2026 election, when the governor and control of the Senate and control of the House are going to be on the ballot. I think Minnesotans rightly wonder why. And it's deceptive. The amendment colonizes and appropriates the concept of the ERA that was a very different thing to push a radical left-wing agenda. It ties together abortion and the erosion of women's rights without clarity of any of those issues. and it ties abortion into many different concepts. 64% of Minnesotans recently were polled saying they wanted that to be separate. We had an unequal rights amendment. This is an unequal rights amendment. We passed up our opportunities to change that. It's exclusionary. It's not about equal rights for all. It excludes only certain politically determined categories of people. It excludes age, and it excludes religion, as we've discussed. It was rushed through the process. We're amending our foundational document, as Representative Pinto correctly said. We shouldn't just be adding words to it. We need to be careful. Is that what happened? No. This was crafted behind closed doors among stakeholders that Representative Herr referred to. But the first hearing on this was less than 2 weeks ago. This language that we're passing off this floor tonight, or this morning, presumably to be passed off the Senate floor in a few hours, maybe with the deciding vote by someone charged with a felony. We're rushing it through the process. Why? Well, because I think the point is that it divides Minnesotans into certain categories. It tells the state of Minnesota that you need to start evaluating policy based on effects to different groups of people. It's all about enshrining identity politics for certain groups into the Constitution. It's extreme and reckless. It's the most extreme abortion policy in the world. It's an extreme erasure of women's rights. It's an elevation of identity politics, concepts of equity and disparate impact, and it's going to result in extreme policy outcomes. We tried asking questions about what this means, and the author refused to tell the people of Minnesota exactly how extreme the policy outcomes are going to be. But here's a few examples of what it's probably going to result in. We currently have laws in the state of Minnesota that permit juvenile violent criminals to be tried as adults. We had an incident not too long ago where even the governor and the attorney general had to take over the prosecution of a case along these lines because it was so extreme that Minnesotans expected it to be. There's a good chance that law gets struck down under this constitutional amendment. The author of the amendment wouldn't tell us how that's going to turn out. We have current Minnesota law that allows parents to opt out of certain curriculum. People make the argument that that is discriminatory or has an effect on certain groups. That's probably going to get struck down. We just, less than 2 weeks ago, passed new fix to the religious exclusions in the Minnesota Human Rights Act. That's up for grabs if we pass this constitutional amendment. That might not be constitutional for us to do that, especially since we didn't protect religious individuals or religion from discrimination. We have education policy, school safety policy. All of that stuff is up for grabs in the courts. The policy of allowing athletes or prohibiting athletes who've gone through male puberty from participating in women's sports. That's probably the point. And we've seen in recent years pedophiles trying to appropriate the language of non-discrimination to claim protected status. There's all kinds of academic literature about this concept of minor attracted people. It's not fun to talk about, but it's real and it's coming. That's the argument that's coming. We tried to clarify that here, and the majority refused with no explanation. But I think the most important thing that we need to think about, what the voters of Minnesota need to think about in this democracy, is the effect that this has on our system of government. This constitutional amendment was written and pushed by activist lawyers who want to make policy through the courts. The same activist group that's primarily responsible for pushing this amendment, that was sitting at the testifiers table in the Rules Committee, has been pushing these kinds of extreme policies through the courts. And that's the point of this constitutional amendment. That's the organization that's suing Catholic schools to try to force gender ideology in their hiring practices. It's the organization that's suing the state of Minnesota to try to force the erasure of sex distinctions in prisons or in school locker rooms or in sports. And we can't get an answer as to what the policy outcomes are going to be for this constitutional amendment. You got to pass it to find out what's in it. Well, here's what's in it. What Abraham Lincoln referred to as government of the people, by the people, and for the people will be no more. It will be government of the judges, by the lawyers, for the activist groups, in particular the activist group primarily pushing this amendment. That is the wrong approach for Minnesota. That's not equality. That's not equal rights. That's unequal rights. That's not Minnesota values. Everyone in this room should vote no. And if by chance the people of Minnesota have the opportunity, they should vote no. And I look forward to the opportunity to explain to all of them exactly why.
The member from Washington, Representative Cha.
Thank you, Madam Speaker. I know a thing or two about discrimination, and I think it's my time to tell you guys a little bit about my experience. You see, my parents grew up in Laos. It wasn't our choice to fight this Vietnam War. Peaceful people, third world country, farmers, displaced from our homeland in China, destroyed our languages, raped our women, killed our men. That's why we left China. Overtaxed us, fought many wars, generations of oppression. I don't know how we survived. But we ended up in Laos, peaceful people of the mountains of Laos, just farmers. The French came, overtaxed us. The Americans came, gave our children M16s to fight the Viet Cong. The same Chinese people that displaced us followed us to Laos. My dad served the CIA, secret guerrilla units, 61 to 75. He didn't want to fight that war, but all his brothers died. He was the only person left. So they said that he must go to war or be in prison. So my dad went to that war. You know why that war happened? Because the Ho Chi Minh Trail came into Laos. And American soldiers couldn't be in Laos. So they sent the CIA to set up the Lima sites in Laos. Radar towers, airstrips, fly recon, missions into Vietnam. Had these lowland people protect these bases. Rescue down American pilots, protect radar sites. Hundreds and thousands of Hmong people died in that war that you guys don't know about. Why? Because it's classified. You want to talk about discrimination? My dad served that war, came to America. He didn't get one dime from the veterans benefit because they couldn't declassify it. They couldn't acknowledge he was a soldier in a war. You know what my dad wanted? He just wanted a VA loan to get a mortgage to buy a piece of land, a house, which he never got. He passed away in 2011. He never got his VA benefits because they couldn't acknowledge he was a soldier. They couldn't verify it. Let me put it on the record. You know why they couldn't verify it? Because the American CIA recruited children under the age of 18 to serve that war, to carry M16s. Children that have never seen guns. They don't even know what an airplane is. They don't even know what a bathroom is. You know what else happened? My community, my parents had to learn English. You know how they learned English? They had to learn English in the jungle, in the middle of the night. Because you know what? If you got caught learning English in Laos, they take you to education camp. They torture you. Some come back, some don't. We talked about religion. I'm Christian, Methodist. My parents converted to Christianity in 1975. I was born in 76. You know how we practice Christianity in my country? We hide our Bibles in the jungle. That's right. Bibles aren't allowed in Laos, nor English books. So my parents had to go hide in the jungle to worship the Lord. Bible studies in the jungle, in the middle of the night. Hide those Bibles in the ground. The God I believe is the same God you all believe in. It's the same God. And so I'm here. Many people died believing in Christianity, speaking up for those families. Many people were tortured and died because they wanted to learn English. You ever been discriminated? I do. I know. My parents know. My people know. Overtaxed, tortured, having your women and girls raped because they're second-class citizens in a country that didn't want you there. We're peaceful people. We didn't ask for these things. I didn't ask to come to America. I didn't have a choice. I'm not an immigrant. I'm a refugee. I had to leave. So my parents left Laos. We weren't poor people. Actually, my family came for parliamentary. They were members of the Royal Laos parliamentary government. That advised the royal courts of Laos, but I don't talk about those things. My parents weren't poor, but we left, crossed the border into Thailand. And you know what happened in Thailand? They put us in a camp. They put barbed wires around it, and they say, you can't leave this piece of land right here because you're not Thai. They put us in a camp, barbed wires everywhere, you can't leave. You know what happened when you left that camp? They locked you up, put you in detention, torture you. We talk about undocumented people. I'm undocumented refugee living in a camp in Thailand. I was born in that camp. and we still believe in God. We took our Bibles with us. Of all the things that we took our Bibles with us to these camps. We hid them, and we did Bible studies in the middle of the night under a flashlight. And the grace of God, in 1980, Catholic Charities sponsored my family to come to America. Came to Iowa, this little town called Sanborn, population 500. I still remember, I got the postcard. I'm from Iowa. You know what's unique about this journey? We have no concept of airplanes, of anything. So you know what happened? Our sponsors put us up in this Rambler for 2 days, and they didn't give us any instructions. We've never seen a stove. We don't have running water. We've never seen these things. They left us in that house for 2 days. They came back and they said, hey, look, what did you guys eat? You haven't used the kitchen. Where'd you get your water? We said, well, we've been cooking outside, and we cut the trees, and we made a stove outside, so that's how we've been cooking. They said, where'd you get the water from? We said, we got it from your well. They said, we don't have any wells in the city. What well are you talking about? Well, follow us. Let's go over here. You see that tub? Every time we flush, water comes in, and we get water from that well. That's right. That toilet, to us, was a well. That's me, coming to America. And here I am, making laws for the state of Minnesota, sharing my experience with all of you. I appreciate all the conversations we have here. I'll be the first to say, I'm honored and privileged to serve with all of you, all of us in here, regardless of your religious background, what you believe in, where you're from. It doesn't matter. These conversations we have in here, the collective of wisdom, the shared experience, the life that we've lived, is what makes this hall so great. And I appreciate sitting here till 4 in the morning listening to all your stories. That's what this is about. Listening, right? Listening. I want to apologize to my daughter, and I'll tell you why. Because as a refugee, being gay and queer doesn't exist in my community. It does not exist. It's as foreign as that Bible and that English book that we learned back in Laos. And I had to grow up with that. I had to learn. You know why? Because I have a daughter who's queer. I couldn't talk to my parents about it. I couldn't talk to my community about it. It's a very foreign concept. It's not accepted. I didn't know how to fight for her. I didn't know how to address her. I didn't know how to handle it as her father. I was ashamed of myself, not because of her. Because I didn't have the tools I need to make her life better, to give her a fair chance at life, because I brought her into this world. I'm responsible for her. As her father, I feel like a failure. I'd be remiss if I don't mention my other refugee friend who came here at 9, who became an attorney, a police officer, and now a district attorney. I won't say his name. But he has a daughter that's transgender. As fathers, we sit together and we share our stories, and we do the best that we can for our children. He's a good man, better than I think I am. And that is why I stand today to share the story with you. I didn't ask for these things, but it's my responsibility, as long as with all of you, to find a middle ground, not only for us, but for Minnesotans. I want to thank all of you. Because it is truly an honor to have an opportunity to share my story with you. Thank you, and I'll be voting green.
The member from St. Louis, Representative Scraba.
Thank you, Madam Speaker. Representative Cha, thank you. Sat on committees with you, heard parts of those stories, and I believe, like you, that's why we're here, to listen. I think we understand each other when we listen. When we talk, not so much. Which leads me into, what did we do here in the last 3 days on this issue? We discussed a lot. I think the state of Minnesota heard us speaking. I think we overturned every rock, every idea, everything on this 2-page bill. What we talked about is going to be talked about for the next 2.5 years. It's going to be analyzed, reanalyzed. It's going to be hashed over what we talked about. I'm confident, if it does make it through the Senate, that people will form their opinions and their ideas. And I don't think there's a winner and a loser right now. I think that comes in 2.5 years. A couple of the things about this amendment that I truly believe, age should be on here, period. And it should be affirming that all people are included, not just the list, all people. How we get that about, that's going to be the selling point. And the state needs to recognize and protect the sex-based distinctions in facilities and programs. These safe spaces need to be protected from the abuse by people who won't, can't, or fail to follow the rules. I was blessed to belong to an organization in Duluth, Minnesota, Northern Lake Second Harvest Food Bank. I spent 9 years on the board, and once a month for 12 months a year for 12 months in a year for 9 years, I went to Duluth. And we toured everything. We gave food to Chum. We collected food. Everything that Second Harvest does, we got to see how it's done. One of the places that we went to was a woman's shelter, an abused woman's shelter. And because I drive from Ely, Minnesota to Duluth, 2-hour drive once a month for 12 months for 9 years, I got a little late one day, and it was down in West Duluth. The house, it was a house, had the address. So I pull up, I walk to the front door, knock on the door, waiting, knock on the door, waiting. I'm like, huh. So I start walking around looking, am I at the right place? About 5 minutes later, a police car pulls up, says, come here. I'm like, what'd I do? And has me sit in the car and asks me all these questions, and I'm like, what did I do? I didn't know. what I had done. The women that were inside that building were terrified because I was a male, and it didn't matter who I was. They were protecting themselves. Our organization was in the basement in a meeting. They had no idea all this was going on. And by the time I got everything cleared up, I got out of the cop car. I went into the house, and I wanted to apologize to all the women and just say, I'm sorry. And they wanted nothing to do with me. I was a male, and I was a threat. So I went downstairs. Again, I can't tell you how it feels to cause that much they were just, it was something I obviously carry with me, to know what I can do just by being there without having any sense of that I'm trying to harm them or hurt them. So when I finally got to the meeting and we got it all straightened out, I started thinking about how these women, what they've been through. What have they been through to be here, to look for shelter? And today we talked at length about safe places. And I have to wonder, who is going to be allowed in these safe places. Even though some of the folks that are going in there, even though they're as harmless and as loving as you can imagine, they're still their presentation, their physical being still will be a threat to the women that are in there. So I question where we're going with this amendment. Is it the right thing? Some of these amendments would have helped. I've been blessed since I've been down here to meet some pretty cool people, some really neat people. And yeah, one of them I got next to me here. I met this year a transgender woman, Representative Gilman, you met her. She's a minority. She's a U.S. Army veteran. And she's having mental health issues. But she's still a person. And she's still someone who wants to be loved. Just like me, just like you, just like everyone. It's something we all have to come to grips with. Because I heard, different folks here talking about how do we treat transgender people. And I've had some experience with it. I understand it. I've spent time with, quality time and learning. And I understand where Representative Finke is saying, we're ready to take that next step. We're gonna push through. I don't see where this amendment is going to help. I don't see it. I think that acceptance, that healing, that comes from something other than a constitutional amendment. And I'm not sure what it is. I'm not sure, but I don't see this being the vessel for that to help that occur. 64% of our population believe that this equal rights and unlimited abortion do not belong on the same ballot. I think it's important that if this is going to survive, if it's going to win, that it should be separate. But if you want to keep it together, I think the handwriting's on the wall that it's going to be a hard sell to pass this to the people. You know, when Representative Wogamont talked about 80% of our population is religious. 80%, if the word religion was in here, you would have had 80% of the population looking at it. I'm kind of glad it's not in there now, because the religious people won't see it and they won't be as apt to support this. I think it has a long way to go. I don't think it's ready. I think we'll find out in 2 years if this goes through. I'm optimistic that our populace, I believe we should change. I believe we should be looking at how can we be better, but I don't think a constitutional amendment is the way to do it. And in these 2.5 years, we're going to have an opportunity to tell our story. And if we tell our story that this is not ready, it's not the right way to do this, we will prevail in the end, and we will be successful. So please vote no. Thank you, Madam Speaker.
The member from Douglas, Representative Franson.
Thank you, Madam Speaker. Members, many times we've heard when Republicans have been in control and we fight for lives of the unborn, we always hear Republicans are pushing divisive social issues. Republicans are, again, fighting for, divisive social issues. And here we are with this unequal rights amendment, and it's a very, very decisive social issue. As we've heard many times over the last few days, that 64% of Minnesotans believe the questions of equal rights and unlimited abortion up to birth should be separate questions. In fact, do you know who also supports limitations in the third trimester? It's Senator Amy Klobuchar. Last year, she said, "I support allowing for limitations in the third trimester that do not interfere with the life or health of the women." And she told that to CNN's Dana Bash on the State of the Union, while also reaffirming her support for codifying Roe v. Wade. That third trimester begins at 27 weeks. And I'm also interested in why, and I made a comment about that yesterday, that why the proposed amendment must be submitted to the people at the 2026 general election. And if ratified, the amendment is effective January 1st, 2027. Just tonight, I heard, "I've been waiting a long couple of decades. I'm not comfortable not being protected. It's time to declare Minnesota a discrimination-free zone." So I guess instead of putting it on the ballot, which could be voted on in 169 days from now, 21 hours and some minutes and seconds, we are waiting to put it on the ballot 897 days, 20 hours and some minutes and seconds. So we're saying, or we're hearing, I'm not comfortable not being protected. But I don't want to be protected in 2024. I want to wait until 2026. It's time to declare Minnesota a discrimination-free zone, but not in 2024. Let's wait until 2026. I've been waiting a couple of decades. I'm not in a hurry to get it on in 2024. Guess I'm really can't wait for 2026. I mean, that in itself is so silly to me. Last year, I asked Representative Bonner the definition of a woman, and she did not know. And now with this bill, this constitutional amendment, we don't even know how this language will affect Minnesotans if it's passed, if it's voted on and passed. So basically, Minnesotans are going to have to vote yes. It takes effect in January 2027. And then through litigation, we will find out how it affects Minnesotans. Members, this is not ready for prime time at all. We talked a lot about gender identity. And according to sexualdiversity.org, gender identity can be understood to include how someone describes themselves, how they present, and how they feel. In this particular website, there are 107 gender identities currently listed for 2024. And it says, and is subject to change at any time. Other websites, 68, 72. Members, how does one work with that? How does one objectify and understand if it's feelings and it changes day to day? I mean, do you understand that? I mean, it's not black and white. It's gray. It's all over. There's no truth. There's no objectivity. All means all. We've heard that. We believe that here on this side of the aisle. That equal rights must include everyone. Everyone. Another thing is that if this amendment were to pass, think about this, there would be no rollbacks. Any legislation that this body would pass to address issues. For example, there was a study that recently came out, and in the study, it said, there was this new study, risk of suicide increases 12 times after gender-affirming surgery. 12 times. More and more studies are coming out about the harms to youth with puberty blockers. With the gender-affirming trans refuge that passed last year, the bill author did not even know how those puberty blockers affected youth. And I had to educate the bill author and this body. And across the world, it's changing. They're rolling it back because it is harmful to children. So members, no matter the size of the hole in your heart, no piece of legislation is going to fill what is missing in that heart. No constitutional amendment is going to make you feel better. You cannot use the legislative process and thrust your will upon the people via a constitutional amendment to fill that hole. The only thing that can fill that hole is through Jesus Christ. I truly believe with the attack on girls' sports that would happen if this amendment would pass, I believe that alone is going to have parents voting no on this amendment. And so we may pass this bill off the House floor and send it to the Senate. But I believe in my heart of hearts that Minnesotans will see through the lie that they are being told, that they are being gaslit with Senate File 37. And I truly believe that they will be voting no in 2026. Thank you, Madam Speaker.
The member from Stearns, the Minority Leader, Representative Demuth.
Thank you, Madam Speaker. And members, as we have heard concerns over this equal rights amendment, and as we have heard personal stories throughout the hours of debate, what I want to draw your attention to is that even though this bill is called the Equal Rights Amendment, and it sounds nice or it sounds fair, but this bill does not provide equal rights to all. We did have the opportunity to vote earlier on a real equal rights amendment, which was the DE5, but it was voted down in this body. And I want to remind you that all means all. This is not an equal rights amendment when you exclude protection for the elderly or when you exclude protection for our most vulnerable. It's not an equal rights amendment when you limit religious freedom. Every person should be guaranteed equal rights and freedom from discrimination. Limiting that number to a narrow list chosen by politicians is unacceptable. Additionally, the wording of the ballot question is extremely unclear, with vague reference to pregnancy that will mislead voters into assuming that they are simply voting against pregnancy discrimination, instead of telling the truth about how expansive this new language would actually be. We learned earlier this week that 64% of Minnesotans oppose a ballot question that would lump together issues of equal rights and abortion. More than half of Minnesota wants those two things separated so it's clear and transparent. Less than 24% believe that it should be contained in the same ballot question. I want to remind you that already in Minnesota, we are equal. This bill about pushing a partisan political agenda and hiding the true intent from voters is wrong. When you enshrine the rights of some, you actually diminish the rights of the rest. So members, I would encourage a no vote on this amendment, on this bill.
The member from Hennepin, the Majority Leader, Representative Long.
Thank you, Madam Speaker. I want to start first by thanking Representative Herr for her stamina in this debate and for her diligence and hard work in bringing this really important amendment before the body. Last year, the Minnesota legislature took the historic step of protecting reproductive rights in statute. This step was overwhelmingly supported by Minnesotans. In Minnesota, we've also had the Doe v. Gomez decision for almost 30 years. Minnesotans have relied on this protection to seek the medical care they need. But after Dobbs, we know that a change in court membership is all that's required to take our rights away. The Protect Reproductive Options Act protected those rights, but there was not a single Republican who voted for the PRO Act. We know that if the GOP was in control, the PRO Act would be overturned. We've seen this play out before. In 2011, the GOP legislature did pass a law banning abortion that Governor Dayton thankfully vetoed. Minnesotans have looked on with shock at what is playing out in state after state as they strip away women's rights. 14 states now have a total ban on abortion, and many more ban abortion before a woman even knows she's pregnant. The Supreme Court wanted this to be a state decision. Well, let's allow Minnesotans to make this decision once and for all. The Equal Rights Amendment would make absolutely clear where Minnesotans stand, that we will not let decades of existing rights be taken away by judicial appointees or changes in legislative control. This Equal Rights Amendment is also critical to enshrining in our Constitution protections against discrimination. We have no such explicit protections in the state constitution. We heard from the minority that they support equal rights, but they didn't want equal rights when they are listed explicitly. There were no complaints on the floor, though, about equal rights for race or for color or national origin, ancestry, disability, or sex. No, the complaints were entirely focused on just one of the protections in the bill, gender identity. Discrimination based on race or sex, well, that's out of style, but discrimination based on gender identity, that's open season, apparently. There is no better demonstration to me of the importance of the work we are doing. There is no better demonstration of why we must be specific about protecting all Minnesotans. The most marginalized, the most discriminated against deserve our highest protections. Constitutional protections for equality do not require people to change their personal beliefs, but they do mean that state actors can no longer discriminate. These protections have been in law for 3 decades. In 1994, with the passage of the Minnesota Human Rights Act, we were the first state in the country to protect against discrimination for transgender people. But given the debate that has played out over the last few days, I think those laws may be at risk if the majority shifts. It is absolutely clear to me that these protections need to be in the Constitution too. Minnesotans reject discrimination of all types. Discrimination has no place in our state, and this is long overdue to include in the Constitution. Thank you.
The member from Ramsey, the author of the bill, Representative Herr.
Madam Speaker, members, thank you for engaging in the conversation tonight. This morning, yes, it's been days. And I wanted to just start by just setting the record straight in a number of things that I heard tonight. First, I want to state that putting the entire work of this body and the individuals who participated in this work and those who came before us and all that's been done onto just one organization, Gender Justice, is misplacing all of the individuals that contributed to this work. You know, and my motives of that it is these organizations leading this work and deciding what we're going to do with this is just erroneous. I'm going to tell you why it is that I decided to take on this ERA work, because this was not mine to begin with. So I am somebody who is very much guided by my faith. My grandfather fought, as Representative Cha said, in a communist country to become the first Hmong Methodist pastor in the world. He also became the first police chaplain here in the city of St. Paul in the country. He is somebody who is of deep faith and somebody who is, has really fought for other individuals. And what he taught me is in John 18:2, that this is my commandment, that you love one another as I have loved you. In Galatians 6:2, that carry each other's burdens, and in this way you will fulfill the law of Christ. But this is really what really struck me was Proverbs 3:27. Do not withhold good from those to whom it is due when it is in your power to act. It is in our power to act now. I really did think about those who shed tears today, sharing their stories and their testimony. I took them to be very genuine tears. I took stories that were told as genuine. I had this actually conversation with individuals who were here in 2012. And when they shared with me that when the Republicans passed 2 constitutional amendments, one in 2012, there was 2, to provide that only a union of one man and one woman should be valid or recognized as a marriage in Minnesota, and the other is to require all voters to present valid photo identification votes. Those individuals, Democrats, said to me, it was so painful for them to actually watch that go on as a constitutional amendment, to have that put on the ballot, that they wanted to lay themselves across the train track and get run over, that it was that important to them. So I can't imagine what you all must be feeling now, thinking that we are doing to you what you did to us in 2012. But the truth is that it mattered to me to think about, well, what was it like? Because I'm hearing a lot of criticism about all of the ways in which this constitutional amendment is so terrible. And really what I want to point out is, and I hope that I find it here because I did have it printed out, is that, oh, here it is. I actually went back and pulled Senate File 1308 from 2012. And I went back and read the language. And what did I find? In all the amendments that were put onto this bill in the 2012, no remedies for harm caused, no information on costs for litigations that could come from this constitutional amendment. What I found is there's no protection of children getting married. I know this because I was the chief author of the bill to eliminate child marriages, because we know that child marriages, usually it is an adult male marrying a child. And we know that the average age difference is enough that is actually constitutes statutory rape. This did not protect children. This did not have all of the things that you're asking me to do in this ERA, this inclusive ERA. I want to remind us that in this ERA, on lines 1.9, it says all persons shall be guaranteed equal rights under the law of this state. What you are all asking for is in this amendment. It states explicitly what you have been asking for is that all people are protected. It is saying it is protected, and the state shall not discriminate against these particular categories that we put in there, because we know that people are discriminated against. I want to be very clear that there is a huge difference between perception of equality and the truth of equality. Because I think it's wonderful if there are women in here who believe that they are already equal to men. I would love for the data to show that. If we were equal to men, white women wouldn't make 80 cents on the dollar for white men. Hmong women wouldn't make 55 cents on the dollar for the same job that white men make. Somali women make the least at 45 cents for that same dollar. That women who are single moms are poorer, live in greater poverty. That women have worse health outcomes because, and depending on their race, it's even worse depending on their race. And if you are a trans woman, you are more likely to die at the hands of violence of other individuals. You are more likely to be sexually assaulted in our prisons. You are more likely to be hurt. And so I wish that we were all equal. I wish that that were the case. And that is why we're saying everyone should be equal. Everyone is equal under this law, except for you cannot discriminate against them because of their race, their gender, their disability. I want to remind us that religion is already protected. It is the core of who I am as an individual. It is something that I cared very much about to ensure that those rights were protected. Nothing changes with this around religion. Religion is still protected. I want to also just talk a little bit about the fact that this bill was not led by gender justice. I'm so confused at the fact that I'm being told that this is being rushed and we hadn't worked on this. But then I was also criticized that I had been working on this for a year with constitutional lawyers, I think that that's how we all should be making laws here, right? Is that we should be doing the work in the off session. We should be gathering our information. We should be ensuring that we have done the work so that when we bring it to this body that we've done that work. And the criticism that it was only heard in rules, it went through the process where it was amended along the process, which is how we make laws here. No one brings a bill to the table and said, it is perfect, let's just pass it out of one committee. That doesn't happen. And when it does, wonderful. But that's rare the case. And so you cannot criticize me at one point and saying it is too fast, and then criticize me for taking such a long time and doing the due diligence I needed to in order to ensure that we've looked at this and talked to people and consulted with individuals who are so much smarter than I am. I want to also talk about the fact of how we've had the language that we have had in here. I think that we really, like Representative Long said, focused on trans women. And I really wanted to draw our attention to the fact that how much we hurt men in this conversation. We talked about men as being pedophiles, as being rapists, as being violent. My God, if that was the world we live in, we should all just be afraid of men in general, because we all sat here tonight and over the last 3 days talked about how awful men were. I just don't believe that to be the case. I believe that, if we are this new feminists who are, fighting for women, we shouldn't be striking down $500,000 of higher ed to take care of, to have a child care that, $500,000 so that we could do something at a university for mothers who have children, that we should be fully paying for paid family leave, that we shouldn't be fighting that, but we sat here and we fought hours upon hours upon hours to ensure that people actually got paid for going on maternity leave. That is not a new feminist. That is somebody who doesn't care about the fact that people need this time off to be with their families. We shouldn't be fighting safe storage and reporting lost and stolen firearms, because we know women die at the hands of violence with firearms from individuals that they are in intimate relationships with. We know that we shouldn't be fighting increasing minimum wage, and yet we sat here on this floor and we fought this for days upon days upon days. That is not the new feminist I am. I'm the kind of feminist who's saying I'm going to build on my mother's 1973 ERA. That's the year I was born. Our times have changed. I've heard people sit here and say we are using worldview words in our language. Lexicon changes. Do you all know, and I say you're not supposed to do this, but I'm just going to state it then, is in our history of Minnesota, we've had 213 proposed amendments to our Constitution. 120 of them have been adopted, and our state did not fall apart when the Constitution was changed. That did not happen. And when this Constitution, do you know how many times people we have in here that women would have the right to vote, to be sit on boards, that Negroes should vote? We don't use the term Negro anymore. These are not worldview words, these are accepted words, and yet here we are using accepted words and we are being told those are just worldview words. They're not real. They are real. Transgender people are here, gender identity, gender expression, those are accepted words because our lexicon changes. We need to accept that. I know we've been here a really long time, but I feel like I've really listened a long time to everybody here, so I hope that you all just give me a couple more minutes to go over a couple of other items that we talked about today. I want to make sure that we address the fact that we are saying some people, we're putting people into different buckets. The thing is, people aren't buckets. They're individuals with sex and gender, reproductive organs, race, color, disability, national origin, ancestry. Every single person in here fell into one of those categories. No one is being excluded. This is an inclusive ERA. I reject the notion that if we give rights to everyone and everyone is equal, that it takes rights away from other people. That we can honor each other and our differences and ask that you not treat me differently because of that. And it doesn't take away from your rights. We have all become better as a state because of these 160 amendments that have been made to our state. Our state is better because of that. And I want to remind all of us that those 2012 ballot initiatives, they failed. Defining marriage and voter ID, they failed. So if the voters decide that what we're doing here is not what they want, then this will fail too. But I have such a strong feeling that's not going to happen because they all can see what has been happening to our state. States across the country, rights being rolled back. The fact that we're all talking about how our daughters are going to have less rights, my daughters have less right today because of the overturn of Roe v. Wade than I did when I had to have my abortion with my ectopic pregnancy. My daughters have to fight harder to have bodily autonomy than I did. Our daughters have less rights now because of courts overturning cases, and this all happened under the watch of individuals who are new feminists. We let this happen. How could that be? We see these rights getting taken away. And I just want to be really clear that we've been talking about cisgender girls and talking about all the awful things that they could do in restrooms. I just want to share that I actually brought my friend who has a trans daughter came to visit me at the SOB. I brought her into the bathroom. And because I'm on the third floor, I had my GOP colleagues across the aisle say to her, "Oh, what a pretty dress. Oh, you're so pretty." They didn't even know she was a trans girl. We're sitting here saying that somehow we're going to be able to tell who they are and they're going to hurt other people. It's like no one even knew she was a trans girl. She just was a little girl in a princess dress needing to use the restroom. They are not a threat to us. What we are doing is we are creating that threat by the narratives that we have put out there today, over the course of these last few days. And I want to just end by saying that, so much, and I know I should keep going to punish you guys a little bit, but I'm not going to. And I just want to say that, of course, the language it became available, you're right, in May, it did. But I think you all understand that when we put out something that is not ready and we know that people are still actively working on, you can't take something back. And the fact that I was protecting it because I wanted to protect the fact that the truth would be out there, and yet I was still fighting lies about this, and how I had taken religion out of the Senate version. Religion was never in the Senate version. It never was. And saying it here over and over again doesn't change that. And so, yes, we should work on truth. We should work on science. And I want to just state here that I know that some individuals were saying that they wish that they would have voted for we were voting for this 1973 language, but yet when Republicans had control, you didn't bring back the 1973 language. You didn't pass it. So this is what you have now. You gave me the time and I made it better. Probably shouldn't have given me that time because I did work a really long time on this. And so today I'm going to bring us back to what we talked about at the beginning of this whole process, is that I do believe in Minnesotans. I'm here in this state. I've lived in Maryland, I've lived in DC, I've lived in Chicago. I came back to Minnesota because I love this state. This state is the state that I made my family, and I believe in the people of this great state. I believe that our Constitution says who we are and what we value. We want to make sure that as Minnesotans, we are valuing each other by prohibiting discrimination, that we must codify protections into the Constitution, and we must be explicit about it. Because I am not fooled by the fact that if I do nothing now, that everywhere in states, I did a couple articles about how certain states are making it harder to actually get divorced because we know what happens to women in situations of divorce and how their outcome is. We're making it harder for them. We're making it harder for them in all different ways that we need to protect it. We know that rights will continue to get rolled back because we see it happening everywhere across the country. And so we have to protect these rights. Case laws and statutes should not be at the whim of political changes and judges who should be nonpartisan, but they aren't. We all know this. The courts are no longer, partisan politics plays a role in how courts operate now. We cannot leave our rights up to on the hinges of individuals who are going to make decisions based on their political leanings instead of making fair decisions. And so advocates and lawmakers, yes, from both sides, have actually worked on the ERA for many, many years. It is time to get this done. It is time we get this done. Thank you.
The clerk will take the roll on the bill. Will the clerk please call the names of the members voting remotely?
Acom.
Acom, aye.
Acom, aye. Carroll.
Carroll, aye.
Carroll, aye.
The clerk will close the roll. There being 68 ayes and 62 nays, the bill is passed and its title agreed to. Calendar for the day. The first bill on the calendar for the day is Senate File 2219. The clerk will report the bill.
Senate File number 2219, the first bill on the calendar for the day, an act relating to horse racing, prohibiting the conduct of historical horse racing and other activities at licensed racetracks, the unofficial engrossment.
There are no amendments at the desk. There is an amendment at the desk, so the clerk won't give the bill its third reading. Representative Stevenson.
Thank you, Madam Speaker. Members, I'll be brief since the hour is very late or early, depending on your perspective. This is a bill that reverses a decision made by the Racing Commission last month to allow historic horse racing slot machines at the tracks, 500 machines at each track for a total of 1,000 machines. The only thing that I will say now, in the interest of time, is I know that at the end of session there's a lot of rumors and swirling around, and given that
Representative Stevenson, I can interrupt you for just a second. There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File number 2219.
Third reading. Representative Stevenson.
Thank you, Madam Speaker. So this will remain just a ban on historic horse racing. It will never be any other bill related to gambling. I just want to note to members that this is a Senate file, and bills that have tax implications have to originate in the House, which of course sports betting would have to originate in the House. So this is just a bill on the historic horse racing machines. I encourage your support.
Discussion. The member from Anoka, Representative Niska.
Thank you, Madam Speaker. I'm sure everyone is looking forward to another speech from me tonight. But here we are. Thank you, Representative Stevenson, for clarifying that this is only going to be about historical horse racing, and also for clarifying what this is, which is the legislature intervening into an administrative decision that's currently being litigated. It's an administrative decision for which there is a huge amount of fact-finding at the Racing Commission and a huge amount of legal argument being made currently up in the Minnesota Court of Appeals around the questions of, what is parimutuel betting? What are the actual mechanics of the historical horse racing machines? And we're being asked to short-circuit that litigation on those facts and on those legal questions in order to decide this essentially legal question ahead of the courts. And as I told Representative Stevenson in committee, I'm actually somewhat sympathetic on both the policy concerns and on the legal issues. Obviously, we shouldn't be letting an administrative agency circumvent the law if that's what they were doing. And I'm not a huge gambling expansion guy. And if we're talking about some sort of gambling expansion problem, I'm interested to know about what are the policy ramifications of that. But I don't think either one of those cases have really been made here. We haven't really talked about the concerns that these particular machines create in terms of gambling expansion. And we certainly don't have before us the machines, all of the contracts, all of the factual background that was given to the Racing Commission, and the legal arguments that are going to be up before the Minnesota Court of Appeals. I did, a cursory look at the statutes, and I think that the Racing Commission probably got it right on the legal questions, at least as far as I can trace the reasoning of what the Racing Commission did. So I'm left wondering why we're doing this. And really, as far as I can tell, all we're doing is intervening for the benefit of one group over another. So that's not what we should be doing. That's not the job of the legislature to step into a court case because we think one party should win and one party should lose. So I'll be a no on this vote. I encourage others to vote no as well. It's just not the right process for us to take, especially at 4:31 in the morning on the last day of the legislative session. It shouldn't be our priority to start just be intervening in court cases for the benefit of one particular group over another. Vote no.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. And looking at our yellow sheet, the author stated this is just about something with horse tracks and betting and et cetera. I'm reading eliminating certain examination requirements, modifying and adding provisions governing the sale of certain motor vehicles, regulating non-bank mortgages, modifying provisions governing life insurance, limiting prohibition on low-cost sales of gasoline. Is it just what the author said, or is there more to the bill? I'm just curious.
Representative Quam, just a procedural note.
That's the title that the clerk read when he reported the bill.
When the clerk reported the bill, he reported the title on the unofficial engrossment, which is what we're working off of. The item that you're referring to is not the current, correct. A calendar for the day does not refer to the current engrossment of the bill. I don't know if you asked Representative Stevenson to yield or not.
Madam Speaker, thank you. I just wanted clarification because what I was reading, what was given to us was different. Thank you.
The member from Dakota, Representative Koznick.
Thank you, Madam Speaker. Representative Stevenson, we had what I felt was pretty good, robust debate when this came to the committee. And so I'm not going to belabor every single point of it. We have a very different point of view and understanding of this. But I think it's important to say, even at 4:30 in the morning, last day of session, we have a bill before us that is apparently a priority to hurt and be punitive to the Minnesota horse racing industry. And in Section 240, what this bill here, members, is the section of law of 240, it establishes the legislature, this body previously established and gave the Minnesota Horse Racing Commission the authority to make the decisions and regulate horse racing in the state of Minnesota. This legislation is punitive and in reaction to actions of the Minnesota Horse Racing Commission, and I hope that if this becomes law, it becomes challenged, because this is not the way we should be legislating in a punitive manner, because some legislators don't like a decision or an action that was taken by the Racing Commission and in fact benefits other parties in the state. And without getting too much into motives, but you can read into it very clearly. And I think that it's just unfortunate. It's not what we should be doing. It should not be a priority at 4:30 in the morning on the last day of session. But what we have is clear. With this bill, the Democrats are being punitive and hurting the Minnesota horse racing industry. It's in this bill as a standalone, and it also was in a different bill that I don't know that we'll have time to get to, the sports betting bill. The horse racing industry has evolved and thrived, ups and downs in the economy. The Horse Racing Commission has studied the historic horse racing operation, the machines that would be used. In the media and such, it was called similar to slot machines, but they determined that it wasn't after much more thorough analysis than what we were able to do in committee. And so I just want to be on the record that this is a Democrat priority to hurt the Minnesota horse racing industry for voting for this. It's shameful that we're taking this up literally in the dark of night, even before the break of dawn. And this is going to pass, but Representative Stevenson and the leaders that have signed on to this is not the role of the legislature. It's in the courts, and that's where it should be adjudicated if there is a discrepancy. We shouldn't be making reactive laws like this, and it's very unfortunate to do that. And so, members, across the chamber, I suggest a no vote.
The member from Stearns, Representative O'Driscoll.
Thank you, Madam Speaker and members. As my Republican colleagues have pointed out, I just want to underscore a couple of things. Number one, the Racing Commission was asked to review this by the racing industry in the state of Minnesota, which has, by all measures, been struggling over the years because of change in law that has affected them and their ability to generate revenue in that industry. They have brought it before. The commission had vetted it. The commission actually sat down, looked at the machines, watched how they worked, and said, no, we believe that this does comply with parimutuel betting. And just to remind you that the members of the Racing Commission are not elected officials. They are appointed by the governor of the state of Minnesota. By all measures, it is not a Republican or a conservative bastion. It is a lot of members on that commission that have I'm not going to impugn their motives on there, but the idea that they're not Republican appointees may tell you a little bit about what their thoughts and processes are being on that commission. When the Racing Commission stepped forward and approved this, immediately there was legislation that was put forward to ban this, and the industry has chosen that they only have the option of litigation to be able to check and to see if in fact, their parimutuel endeavors are in fact taking place here or not, or is it something that is illegal? And one of the things I brought up in committee, and I'm going to ask Representative Claiborne to yield to a question, as she's the chair of the State Government Finance and Local Government, and she is also on the Commerce Committee. Representative Claiborne, you may recall in committee I had asked about the idea of habeas machinus. And habeas machinus is bring the machines to the committee and let the committee see how this is done. And I saw you scurrying and writing some notes that day. We did not have the benefit of having that in the Commerce Committee. I was just wondering if you were afforded the opportunity in the State Government Finance Committee when you had this bill to see how those worked and how your members reacted to that.
The member from Hennepin, Representative Claiborne.
Thank you very much. And Madam Speaker, what we did see in the State Government Committee is that we were given handouts which clearly show the likeness of the equipment. We were given letters from the, let me just find it here for a moment. We received the letter from the Enforcement Agency, which stated the Alcohol and Gambling Enforcement Division, which is the law enforcement agency for gambling enforcement. And in that letter, it says, in considering the physical appearance of the machine, it presents itself as a multi-reel, multi-line video slot machine. This is a common form of gambling found within Minnesota elsewhere. And it says that in considering the play of the machine, the AGE notes that the HHR machine operates from a seed pool and a banked seed pool reserve, which is utilized to pay out player winnings. The winnings are specified or specific to the individual player and are not truly part of a pari-mutuel pool. So we had documentation that showed us what the machines look like, how they replicate the slot machines that are in other facilities in our state, and then we had a definition defined by the Minnesota Department of Public Safety, Alcohol and Gambling Enforcement.
Representative O'Driscoll.
Thank you, Madam Speaker. So thank you, Representative Claiborne and Chair Claiborne for that. The short answer, in case you didn't get it, is no, they didn't see it. They saw the same paperwork we saw in the Commerce Committee, which does not apparently do it justice from what the Racing Commission saw. So we have two different government agencies that are viewing this differently, and the legislature is deciding to step in and to limit the private right of action that individuals have in the industry to have their day in court. We're just going to make it illegal and once again compromise the racing industry in the state of Minnesota. So members, if you are voting yes, you are voting to make it more difficult for horse racing in the state of Minnesota. If you vote no, we will allow the horse racing industry to have their day in court, and we'll see what these agencies and whether their interpretations were correct. Thank you, Madam Speaker. Members, I recommend a no vote this evening.
Representative Stevenson.
I ask members to vote yes.
The clerk will take the roll on the bill. Will the clerk please call the names of the members voting remotely?
Acom.
Acom, aye.
Acom, aye. Carroll.
Carroll, aye.
Carroll, aye.
The clerk will close the roll. There being 71 ayes and 58 nays, the bill is passed and its title agreed to. Representative Long.
Madam Speaker, I move to continue the calendar for the day.
Representative Long moves that the calendar for the day be continued. All those in favor, please say aye. Those opposed, please say no. The motion prevails. Messages from the Senate.
Message from the Senate, Madam Speaker. I hereby announce the Senate has concurred and adopted the report of the Conference Committee on Senate File Number 5289, an act relating to economic development. The message is signed Thomas S. Bodern, Secretary of the Senate. Conference report on Senate File 5289. The report is addressed to the Honorable Bobby Joe Champion, President of the Senate, the Honorable Melissa Hortman, Speaker of the House. We, the undersigned conferees for Senate File 5289, report that we've agreed upon the items in dispute and recommended as follows. The report is signed by 3 of the 3 conferees on the part of the Senate and 3 of the 3 conferees on the part of the House. Hassan moves that the report of the Conference Committee on Senate File Number 5289 be adopted and that the bill be repassed as amended by the Conference Committee.
The member from Hennepin, Representative Hassan.
Thank you, Madam Speaker. That's my motion.
On the motion to concur to adopt the Conference Committee report, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The clerk will give the bill its third reading as amended by conference.
Third reading, Senate File Number 5289, as amended by conference.
Third reading as amended by conference. Discussion to the bill. The member from Hennepin, Representative Hassan.
Thank you, Madam Speaker and members. I know it's late at night and our mental clarity is probably not all here. I want to thank our staff members who have worked tirelessly with us. I also want to thank our conferees, Jerry Shong and Representative Selesnikar. This is a great bill. It's a bill that, empowers our workforce. It touches on every part of the state of Minnesota, and it also, gives resources where it's needed. Please vote green. Thank you.
The member from Candy, Ojai, Representative Baker.
Thank you, Madam Speaker and members. I want to say this is a good bill. This is it's a good bill because you worked with us again too. It's a good bill because you included us in creating a better bill. It's not a perfect bill. It still spends money. We really did so much last year, and I've said that many times on the House floor. But there's some good policy in here too. You recognize projects around the state of Minnesota from the Workforce Fund. And again, I think I also just, a shout out to Chairman Zhang. He fought hard for the House position, and he had, I think it was not an easy position from his Senate colleague. I just want to say thank you, Representative, for that fight. You're a good chairman for that. I think you really did believe in your mission here. So, members, I plan on voting on this as it passes out. Again, I'm not sure that everybody will do that, but I think because of the process, because of the fight that we did have on this one, we can support a bill like this and help people around the state of Minnesota in a better than what we've seen in other bills. So I appreciate that, members. I'll be supporting the bill. Thank you.
The member from Ramsey, Representative Zhang.
I was not prepared. Thank you, Madam Speaker.
Sometimes I think I see nods that apparently I don't see. Representative Zhang.
Well, thank you, Madam Speaker. I want to thank Chair Hassan and Representative Selesnikar for both of their leadership. There were times I walked away and they both brought me back and said, no, we need to get a jobs bill done this year. So thank you both. And of course to our staff, partisan and nonpartisan, and of course the senators who worked with us. I do want to note that we passed the bill out of the House with 17 million. We used up our 17 million target, but we came back with a $12.4 million. So we went under a little bit. Unfortunately, the Senate did not see eye to eye with us with some of the other fundings for Greater Minnesota and here in the Metro. But at the end of the day, we still got something done. So I'm very proud of the work here and looking forward to green votes.
The member from Dakota, Representative Koznick.
Just real briefly, members, from the economic development portion, wasn't a lot of money, but just had a little bit of concerns with some of the overall spending in the bill. I will not be voting for it, but I appreciate the work of the committees.
Seeing no further discussion, the member from St. Louis, Representative Zalesnikar.
Thank you, Madam Speaker, and members, I'll be brief, but I wanted to thank Chair Hassan and Chair Zhang. They were fantastic to work with, and I appreciate being able to have a bipartisan conference committee. I think we did some really great things. The Entrepreneur Fund is really important to Greater Minnesota, and I just want to thank you for hearing my concern for this. And Women Venture is a great opportunity for childcare in the state, and that is a huge initiative. And Greater Minnesota is going to have some great programs too. So I just wanted to say I think this is a great jobs bill, economic development that we need to be, and I encourage members to vote green, and thank you.
Seeing no further discussion, the clerk will take the roll on the bill. Will the clerk please call the names of the members voting remotely?
Acom.
Acom, aye.
Acom, aye. Carroll. Carroll, aye.
The clerk will close the roll. There being 83 ayes and 47 nays, the bill is repassed as amended by the conference committee and its title agreed to. Motions and resolutions. There's copies of the non-controversial motions at the House desk and online. If there's no objection, we'll take action on these motions first. Hearing no objection, the motions prevail.
Pursuant to Rule 4.31, Olson B. presented a written demand to the Speaker on Tuesday, May 7th, 2024, for the immediate return of House File Number 4803 from the Committee on State and Local Government, Finance and Policy, be given its second reading, be placed on the General Register. The initial request was printed in the Journal for Tuesday, May 7th, 2024.
Second reading of House files.
Second reading House File Number 4803.
Second reading. Announcements. Representative Long.
Madam Speaker, I move that when the House adjourns today, it adjourns until 9 a.m. Sunday, May 19th, 2024.
Representative Long moves that when the House adjourns today, it adjourns until 9 a.m. Sunday, May 19th, 2024. All those in favor, please say aye.
Aye.
Those opposed, please say no. The motion prevails. Representative Long.
Madam Speaker, I move that the House do now adjourn.
Representative Long moves that the House do now adjourn. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The House stands adjourned until 9 a.m. Sunday, May 19th, 2024.